are some advantages.
What do you think those advantages are?
Well, because he's more familiar with the ins and outs with the court system and stuff like that, and with the case laws. But when you have a lawyer that don't talk to you about what really happens, then that becomes the issue.
Okay. Do you know what the term ineffective assistance of counsel means?
Yes, I do.
That means, in my world, that means if you're not effectively represented at the trial, you may have the right to appeal based upon ineffective assistance of counsel. If you represent yourself, you don't get to argue to the Court of Appeals that I didn't effectively represent myself. You understand that?
Yes, sir.
You don't have the funds to hire a lawyer, so we appointed one for you. Do you understand, at least from my perspective, if you represent yourself, you're probably going to be hurting your case. Do you understand that?
Yes, sir.
All right. At a trial, there are certain decisions that the lawyer makes, and there are certain decisions that the client makes. So a lawyer, for example, decides what strategy to use at trial, what to say in opening statement, what witnesses to present, what jurors to strike. Those are the sorts of decisions that the lawyer makes. On the other hand, there are decisions that the client makes. The client makes decisions about, for example, whether or not you're going to testify. So if Mr. Engel were to represent you in the case and he said, you're not testifying in the case, and you said, yes, I am, that is a decision that you would make as the client, even though you're represented by a lawyer. But when it comes to calling witnesses, for example, and I know that we have several witnesses coming tomorrow that you requested. I think there's like 3 or 4 that we have transport orders for that we did at your request. Mr. Engel may decide ethically he has no good faith basis to call one of these witnesses. That would be his decision not to call the witness, and you don't have the ability to override that decision if you're represented by a lawyer. Do you understand that?
Yes, sir.
If you represent yourself, you decide what witnesses are going to testify. You decide what your strategy at the trial is going to be. I might disagree with it, but it's your decision. However, there might be some issues that you try to raise or believe that are relevant that aren't. If so, Ms. Tranter may make an objection. I may rule on that objection and sort of guide you back to what is more relevant to the case. You understand that?
Yes, sir.
Do you know what a standby counsel is?
Yes, sir.
What's your understanding of what a standby counsel is?
Standby counsel is somebody that assists you, but during trial, he can't help you during the trial.
It's a pretty good description of a standby counsel, Mr. King, because if you decide to represent yourself and if I decide to let you represent yourself, Mr. Engel is not going to sit there. He's going to sit in the row behind you. And the idea of a standby counsel is that he's available for routine sorts of things, procedure, evidence. If you have questions about courtroom protocol or about the local rules, you can ask him any question that you want, but he's not going to volunteer any information. He's not going to make any unsolicited suggestions. It's not the job of standby counsel to give you tips, trial strategy, any of that sort of thing. I want to make sure that the jury is not confused about his role. That's why I put him on the other side of the bar, because I think if I put him there next to you, the jury is going to incorrectly assume that he is representing you. Also, though, the standby counsel's job is if at any point in the trial you change your mind about representing yourself, or you behave in such a way that I can't continue to let you represent yourself, Mr. Engel is going to step in and begin to represent you. He's not going to like that very much, because the first thing that he's going to do is ask me to continue the case so that he can get ready. I'm going to tell him no to that, because as far as I'm concerned, Mr. King, this is your decision. If it turns out to get a little bit messy, you're the one that's responsible for that mess. Does that make sense to you?
Yes, sir.
So the way I would look at this is, if I were you, I would look at Mr. Engel like a book. If you want to open that book and read it, it's available to you. If you want to just leave that book alone and not even use it, that's your right also. Do you understand that?
Yes, sir.
Mr. Engel is experienced in being a standby counsel. I know he's been standby for me at least once, right, Mr. Engel?
I believe so, Your Honor. Yes.
Okay. So he kind of knows how this is going. Do you understand the purpose and role of a standby counsel?
Yes, sir.
Do you have any problem with that?
No, sir.
Who decides if you're guilty or innocent?
The judge or the jury.
Okay. No. I don't decide whether or not you're
Well,
guilty or not.
if it's a trial by judge, it's up to the judge. If it's
Okay.
a trial by jury, it's up to the jury.
Okay, that's a good clarification. I assume, though, Mr. King, you want to try this case to a jury, right?
After what I done been through with the juries, I prefer this to have you as my juror and judge.
Okay. Let's talk about that after we get to the end of that, whether or not did I print out a counsel waiver? I don't think I did. I need a written counsel waiver. Maybe I can print that out. I just remembered about that. All right. So at the trial, you have the right to confront the witnesses that are called against you. Do you understand what that means?
Yes, sir.
What's your understanding of what that means?
That means you got the right to question the witnesses about the effect of what happened on that incident day.
Okay, that's partially true, and that's the most important part of it. But also, one of the things about confrontation, Mr. King, that some people tend to forget is you have the right to see and hear all of the evidence in the case, same as the judge or same as the jury. So no evidence is going to be taken in this case that you are not present for. If Ms. Tranter calls a witness, none of those witnesses are going to be permitted to step down from the witness stand until you have the right to cross-examine them if you're representing yourself, or if Mr. Engel's representing you until he has the right to cross-examine the witness. You also have the right to look at all of the physical evidence, which I understand that you've seen all the videos and that you've seen all the evidence, right?
Well, I seen all but one video. That was the last video. He was telling me that was blurry.
Okay.
So
If there is any evidence that comes up in the case that you have not seen, Mr. King, I want you to bring that to my attention. Can you do that?
yes, sir.
All right. We also have the right to compulsory process. That means that you have the right to have witnesses come and testify on your behalf. And if they won't do so voluntarily, we can issue orders and subpoenas to make sure that they come. Do you understand the right of compulsory process?
Yes, sir.
I don't know if these witnesses, I think at least one of these witnesses maybe did not want to come. I don't know that we're at that point yet. I might be thinking of a different trial. But if there are witnesses, or this also extends to evidence, documents, those sorts of things, if you want to present those, we'll get those for you by the way of subpoena. Do you understand that?
Yes, sir.
You have the right to remain silent at the trial. It's kind of a bit of a sticky wicket when you're representing yourself, because you have the right to remain silent, but you're going to be talking the whole time. So if you try this case to a jury, I will advise the jury that you have two jobs in the case. You have the job as your own lawyer, and you have your job as the defendant. Unless you take the witness stand, raise your right hand, swear that you're going to tell the truth, all of those things, none of what you say at the podium or from counsel table, none of that is evidence. Do you understand that?
Yes, sir.
The state of Ohio is not allowed to call Todd King as a witness in the case. Whether or not you testify is up to you. And if you exercise your right to remain silent, I'm going to tell the jury that they are not to hold that against you in any way. If I hear the case myself, I'm not going to hold the fact that you remain silent against you in any way. Do you understand that?
Yes, sir.
Probably the primary reason that sometimes people do not want to exercise their right to testify in a case, and they want to exercise their right to remain silent, is because if you take the stand in the case, I would imagine that Ms. Tranter is going to cross-examine you about your prior criminal history, and it may be that it makes sense not to have that come in. Do you understand that?
Yes, sir. But may I ask
Sure.
a question? Now, coming to my prior history, everything I have is back from 79 except for 2019. So everything else is, can't be brought up anyway.
Yeah, I don't know what your criminal history is, Mr. King, But I can say this, if you're going to testify in the case, the jury is probably going to hear that you are in prison for the charge of felonious assault. If you don't testify in the case, the jury is going to know that you're in prison. They're probably not going to know why unless you tell them. Do you understand that?
Yes, sir.
All right. Do you understand what proof beyond a reasonable doubt is?
Yes, sir.
Okay. You're presumed to be innocent in the case. Do you understand what that means?
Yes, sir.
Essentially, what that means is, Mr. King, the state of Ohio has to prove that you are guilty. They have to do this beyond a reasonable doubt, which is the highest burden that we have in the law. If they don't prove every essential element of the case, then I'm going to instruct the jury to find you not guilty. And if I hear the case, if they don't prove everything beyond a reasonable doubt, I am going to find you not guilty. I'm going to give the jury an instruction that basically says, and I'm not reading it verbatim, but it's going to say that you have to, it's proof of such character that an ordinary person would be willing to rely and act upon it in the most important of that person's affairs. That's generally what the proof beyond a reasonable doubt instruction sounds like. Do you understand that?
Yes, sir.
So we have some rules at the trial, and one of the rules that we have is the rules of evidence. That's generally where most people who represent themselves run into trouble, because there's only one rule book, and I don't change the rules because you're representing yourself, even though I am going to make as many accommodations for you as I can. It's not fair, though, for me not to hold you to the same rules. Do you understand that?
Yes, sir.
Are you familiar at all with the rules of evidence?
Yes, sir.
All right. Do you think that you would be able to handle that part of it in presenting your case?
I believe so.
Okay, because the state of Ohio, they're going to be represented by an experienced attorney in the case. And I'm going to hold you to the same standard that I hold Ms. Tranter. You're going to have to follow the rules of evidence and procedure. What's really frustrating, Mr. King, and I've had this happen, when somebody's representing themselves, they have a document that they want to get into evidence. Everybody in the courtroom knows how to get that document into evidence. I know, Ms. Tranter knows, Mr. Engels, everybody knows except you. And it's very frustrating to watch somebody try to figure it out. Now, you're going to have Mr. Engel available to you as standby counsel, so you can lean over and ask him, hey, how do I get this into evidence? He might try to help you to the best of his ability. Do you understand that?
Yes, sir.
We've talked a little bit about this a couple of minutes ago. You have the right to have the jury decide the case if you want. That means that we'll impanel a jury of 12 people, and all 12 of them would have to be convinced beyond a reasonable doubt that you're guilty of this in order to find you guilty. They also have to have a unanimous verdict that you are not guilty, and if they can't agree, that's a hung jury. If you waive your right to a jury, I'll decide whether or not the state has proven beyond a reasonable doubt that you're guilty of this. You understand that?
Yes, sir.
Just to give you a brief overview of the trial, you've been through a trial before, so you kind of know how this works, but I'll tell you the way that I do it. The first order of business is what we call jury selection. That means that the jury that's checking in here in a couple of minutes, they're all going to be brought into the courtroom. Some of them are going to be put in the box. 12 of them are going to be put in the jury box. The rest of them are going to be seated behind you. Then we're going to have a process called voir dire. We're going to talk to the jury about what the trial is about. I'm going to explain to them a little bit about what you're charged with. I'm going to ask some questions about whether or not they can be fair and impartial in the case. You're going to get an opportunity to question the jury also. So the way this works is I will ask them the initial questions that I have for them. We have things called jury questionnaires, and you're going to get those jury questionnaires that you can look at during the trial so that you can talk to juror number 8, for example. Let's say it's Ms. Johnson. You can look at her and you can see that Ms. Johnson has, she's employed maybe by the prison, for example. You could talk to her about that, how that may affect her, whether or not she knows any of the people involved. The idea is to get a jury that is fair and impartial to both sides. I do limit everybody to 20 minutes for their part of voir dire. Everybody complains about that. I don't expect you to be any different than that, Mr. King, but that's the way we do it. Then we exercise what we call challenges for cause. That means if you think that any of those jurors can't be fair to you, then you'll exercise a challenge for cause. We may have a chat about whether or not they can be fair. I may excuse them. I might not. Then we have what's called a peremptory challenge. That means that both you and the state of Ohio have 4 challenges, which you can get rid of somebody for any reason or no reason whatsoever. We just excuse that person, put the next person in, and we go on with the voir dire process. Do you think you understand jury selection?
Yes, sir.
After that, I give the jury some initial instructions, and then we do opening statements. Opening statements are a preview where you can tell the jury what they expect to see in the case. Then we have witnesses, first by Ms. Tranter and then by you. Then after the evidence close, we have closing arguments. Then we have jury instructions. If you represent yourself in the case, I anticipate that I'm going to have a draft of those instructions to you probably by mid-afternoon. There's already been a dispute that has broken out over the jury instructions based upon a case that I had with these folks not too long ago. So we're going to have a discussion about what the self-defense instruction should look like for somebody who is in a prison. Because when you're in prison, the corrections officers, they have a legal right to exercise some amount of force on you that they may not be able to exercise on me or Mr. Engel, for example. So if they tell you, hey, you need to move out of the way, and you don't move out of the way, they're allowed to push you a little bit to the side, what we call minimal or nominal amount of force. They're allowed to manipulate your hands, your feet, to put you in cuffs, those sorts of things. All of those things are allowed. But then we also have something called excessive force, which means that you are subjected to force that goes beyond that. I'm not going to get too deep into that because if we have a discussion about that, it's going to be a pretty sophisticated discussion that's going to take place later. But it does have something to do with your legal defense. Do you understand that?
Yes, sir.
You're going to be shackled throughout the trial. So, you're serving a prison sentence for a crime of felonious assault. You're accused of felonious assault. This level of violence overcomes your constitutional right to be free from shackles during the trial. I do understand, though, that we have some civilian clothing for him. Is that right?
That is correct, Your Honor.
So you can be dressed out in civilian clothing, but you're going to be shackled. And as we talked about at the conference, if you sort of scooch up under that table, jury's probably not even going to notice that you are shackled. They might. I'm going to tell them not to worry about that it's just the same sort of thing that we do in every case. But if you're up moving around representing yourself, jury's going to notice a little bit more that you are going to be doing your lawyer type stuff, that you're shackled. Do you understand that?
Yes.
Do you have any questions about that?
No, sir.
All right. The right to represent yourself is not the license to abuse the dignity of the court, to disrupt the proceedings, generally to be sort of a pest of yourself. If you become disrespectful or disruptive, then you will forfeit your right to represent yourself, and Mr. Engel will step in to begin to represent you. One of the things that is a little controversial amongst my judge colleagues, Mr. King, is what level of disruption or disrespect we have. When you're representing yourself, you may not talk the same way that I talk or the way Mr. Engel talks or even the jury talks. You may use offensive language, cursing, slang. I don't consider any of that to be disrespectful. So during the trial, I don't want you to search for the right word that's not going to hurt anybody's feelings. You talk the way you want to talk, and I don't find that to be particularly disrespectful. But if you're going to start yelling, if you're going to start screaming, pointing your finger, doing all of that kind of nonsense, that's disrespectful and disruptive. I'm not going to allow you to do that. My general rule of thumb, Mr. King, is if you're representing yourself, you can say whatever you want from your seat. If you stand up or you start gesturing, then we're going to intervene. Do you understand that?
Yes, sir.
You are going to be a little bit restricted if you're moving around. You're going to use this path behind Mr. Engel. You're going to go up to the podium, and you're going to use that path back. That's essentially the how you're going to make it to and from the podium. I'm not going to let you wander around the courtroom. I don't let anybody wander around the courtroom, though, Mr. King. So that's sort of the way that goes. If you're found not guilty, then you're going to go back to the institution. Nothing happens. If you are found guilty, then we are going to go forward with a sentence. Sometimes we do what we call a pre-sentence investigation. I generally don't do those in prison cases, but if you're convicted, we will talk about whether or not we should jump right into the sentence or we should do a pre-sentence report. Do you understand that?
Yes.
The factors that I consider in sentencing, they are the seriousness of the offense, the impact on the victim, your criminal history, and essentially I will allow you, and this is all if you're convicted. I'm not saying that you're going to be, but we don't really talk about the penalties if you're found not guilty because nothing happens. Then I'm going to essentially listen to anything that you want to tell me about why this offense is not as serious for the purposes of sentencing. Do you understand that?
Yes.
I think, have we only had one other trial? You said you went to trial. Is that the only time that you've ever been to trial before?
Since 2019.
Have you ever been to trial before in a case?
Yes.
Okay. The case that you're in prison for, that was in front of a judge in Montgomery County, right?
Yes, sir.
Were there any other trials before that?
Yeah, a long time ago, back in the 70s.
Oh, okay. Back in the 70s. Well, whatever happened in the 70s, we try not to put too much weight on. All right. So, Mr. King, do you think you understand your right to represent yourself?
Yes, sir.
Has anybody made any threats, promises, or representations to get you to waive your right to be represented by an attorney?
No, sir.
Do you think there is anything about our discussion today that has impacted your desire to represent yourself?
Not really. I just wanted to talk to Mr. Engel real quick to see his opinion about something,
Okay.
and then we go from there.
All right. So I will let you and Mr. Engel talk. When we come back, we're going to talk about, number one, do you want to represent yourself? And number two, do you want a jury to decide the case?
Well, since the last jury trial I had back in 2019, I would prefer to pass on the jury and just take the judge.
All right. I think, Mr. Engel, it makes more sense to do those in reverse order. So why don't you talk to Mr. King first about his right to a jury? Because if you waive your right to a jury, Mr. King, then I really worry a lot less about things like standby counsel and the rules. Because if you want to represent yourself in front of me, Mr. Engel is going to be right next to you because I don't have to worry about me being confused about standby counsel. I will understand the role of standby counsel. I'm not going to get confused about him representing you. And I also, if there's no jury, you and he can discuss matters at counsel table. So if something comes up and you say, Judge, give me a second, I want to talk to Mr. Engel about that. He just leans over and you guys have a discussion. The reason that I don't let you do that where there's a jury here is because then the jury is naturally going to assume that he's representing you, because on TV, they see a guy in a tie representing a guy who is not in a tie. They're going to think that he's representing you, even if I tell them not. So let's cross the jury waiver off the list first, and then we will decide whether or not I mean, they're sort of entwined with one another, but why don't you guys talk and then you let me know what it is that you want to do. We will take, how's 10 minutes? Is that enough time? Let's take 10 minutes to figure this out. And I understand that the jury is in the process of checking in now.
Can we talk in here, Your Honor?
I mean, I'll clear the courtroom except for security. And as long as that red, Mr. King, we broadcast our proceedings to YouTube. That means that there might be people watching us. There might not be. I don't know. If that red light is on in front of you, that means there is sound on the YouTube. If that light is off, that means that the YouTubers can still see you, but they can't hear you. Do you understand that?
Yes, sir.
All right. Anything else? Let's go ahead. After we go off the record, just fix the camera on the bench. That way they can't see if anybody's watching. I don't know if they are. Okay? All right. 10 minutes. We'll clear the courtroom except for the security people so that you can talk.
Thank you, Your Honor.
We're in recess.
This to January 27th at what time, Jen?
I'm just looking to see if they're on the, that would be 10 o'clock.
10 a.m. So you can go ahead and do that. Do you intend to apply for funding?
No, I intend to vacate within 45 days.
Yeah, Your Honor, this is actually a termination.
I'm sorry. Okay, thank you. So, all right. So I'll give you 2 weeks to still speak to a lawyer. And then we're going to come back. But if you haven't vacated, I'm going to end up giving them a judgment there. Okay. So this will be January 27th at 10 a.m.
Okay, I'm currently just, my request would be for 45 days to vacate the premises, if that's reasonable.
It's, you're only entitled to 10. You're buying 2 more weeks here. I'm not going to be able to do that for you. So that's,
Yeah.
I don't know what else to tell you. Okay.
All right. January 27th.
27th at 10. She'll talk to you on chat and tell you how to get a hold of the lawyer. Good luck.
All right, thank you very much.
Point versus Mariah Reeves, 2505240.
Good morning, Your Honor. Jen Wilburn, P83143 for plaintiff.
Good morning, Ms. Welburn. Do I have defendant here? Defendant was not served last time. I assume the defendant's been served, Jen.
Which defendant, Your Honor? I apologize.
Mariah Reeves.
I'm here.
Yes, she's here.
Oh, I'm sorry. Your name, ma'am?
Mariah Reeves.
Did you listen to and understand the rights on the video?
I didn't get to see a video. It put me in a waiting room.
All right. You understand you have the right to an attorney and the right to a
Judge,
jury?
this is we have this as a second hearing, so that's why we didn't show it.
No, I adjourned it because she was not served
She
the
was not
first
served.
time.
Yeah, these should be first hearings. I understand. Give me one. I can send her into the breakout room.
No, I'm going to go ahead and
Okay.
advise you of your rights orally. You have the right to a lawyer. You have the right to proper venue. You have the right to a jury trial. You have the right to apply for funding. You have, there's also the possibility of a conditional dismissal being entered into, and you do have the right, as I said, to a lawyer. Would you like an attorney to talk to?
Yes, I would like to speak to one.
I'll adjourn this to January 27th at 10. Or what time, Jen? 10?
Let's do 11, Your Honor.
Do I have something in the morning there or what?
Yes, you have a general civil docket.
Okay, at 11 o'clock, and she's going to chat with you. You have the right to speak to a lawyer. Do you intend to apply for funding, ma'am?
I did just apply for funding and submitted in my proofs this morning.
You have to submit proof of funding. You have to submit proof of application for funding within 5 days, okay? So you have to
Alrighty.
bring that up here, all right?
Alrighty, thank you.
All right, so just wait right there for a second. She will tell you how you talk to the lawyer. Good luck, ma'am.
Alrighty, thank you.
Gibraltar Point versus Ali Hamza, 2505241. Ali Hamza.
Jen
Your Honor,
Wilburn,
defendant. Go ahead, Ms. Wilburn.
P83143 for plaintiff.
He has not appeared, Your Honor.
Okay. All right, you can go ahead and take your default.
Judge, we show an outstanding rental balance, $1,280. I've got late fees with the court's cap too, so it comes out to $140. So $1,420 plus $184.17 in costs, total $1,604.17. I believe the writ date we're working with is the 22nd. And I know
Can I ask you a question? How much did you say in costs?
$184.17.
All right, so you're asking for a writ date of the 22nd.
Correct.
Are you going to get that to me this morning?
I am, Your Honor.
Okay, because I'm getting these late. I'm not saying from your office, but for the other lawyers, you got to send them to us that day, or you have to put in the next day as a writ date, okay?
Judge,
Because
you
we're
have
entitled to
my
10
word.
days.
I'm real
Okay, so
timely
send
about
that
it.
over and I'll go ahead and give you the judgment.
Thank you, Judge.
Writ date will be the 22nd. Gibraltar Point versus Timothy Browning, 2505243.
Jen Wilburn, P831143 for plaintiff.
Service was not accomplished last time. Was it this time,
Yes.
Jennifer?
Yes, it has been accomplished and he did not appear.
All right, you can go ahead and take your default.
Rent to retain, $1,191.47. One late fee at $70. That comes out to $1,261.47. Court costs $184.17. Total $1,445.64 to be paid by January 22nd.
And failed to appear. Writ date will be the 22nd of January. The amount to be paid to save it is $1445.66. Gibraltar
64, Your Honor.
versus Alexis Myers, 2505244.
Jen Wilburn, P831143 for plaintiff.
Ma'am, your name?
Alexis Myers.
Did you listen to and understand the rights on the video?
Nobody sent me to a video.
Judge, but she was in the courtroom when you just read them to Miss Reeves.
Did you hear the rights that I just said about the right to a lawyer, the right to apply for funding, the right to a jury trial? Did you listen to all that I just covered with one of the other defendants?
Yes.
Do you wish to speak to an attorney?
Yes, and I already filed for funding.
Okay. We're going to send you a link or a e-chat, chat, whatever. Who wants to speak with attorney? Applied for funding. You need to bring in your application for funding here to the court.
I'll bring it today.
Hang on, within 5 days. Do you understand that?
Yes.
Okay, we'll adjourn this to January 27th. That will be at 11 o'clock in the morning, okay?
Okay, thank you.
All right, good luck. Do you have any more, Ms. Wilburn?
I should have one for SRM Group and defendant Siobhan Brown.
SRM, hang on. Is that what you said, SRM?
Correct.
SRM Group versus Siobhan Brown, 2505246.
Jen Wilburn, P83143 for plaintiff.
Do I have the defendant here? Oh, there you are, ma'am. Good morning. Your name?
Good morning.
Your name?
Siobhan Brown.
Did you listen to the rights?
I did.
Did you understand the rights?
I do.
You wish to speak to a lawyer, or have you applied for funding?
I applied for funding. No lawyer. It's not necessary.
All right, I'm going to adjourn this for 2 weeks to January 27th at 11 a.m. You need to provide us with proof of the application for funding within 5 days, okay?
Okay. Your Honor, can you repeat the date again?
January 27th, January 27th. That's
Okay.
2 weeks from tomorrow, and that will be at 11 o'clock in the morning.
Is that in person or on Zoom?
No, you can come on Zoom.
Okay, thank you. That'd be better.
Have a great day. Good luck.
Thank you.
Slats Enterprises versus Amy Brown. Is that it for you, Ms. Wilburn?
For now, Judge, I'll be back at 10.
All right.
Thank you. Can I go?
2502587. Thanks.
I can't get it.
05287. 2505287 Slats versus Amy Brown. Is Amy Brown here?
Your Honor, Miss Brown has logged in late. We have her in the breakout room watching the video right now.
Let me go on to another one, Mr. Sims. As soon as she comes out, I'll call you, okay?
All right, thank you.
Primary Estates versus Rafael Santana and all occupants 2505288.
He was here, Your Honor. See where he went. He was here in person.
Well, you know what? Counsel, your appearance.
Good morning, Your Honor. Fatma Packer on behalf of Primary Estates LLC.
Give me 1 second.
No problem.
I don't know why there's this tendency for parties to stay in the hallway. Can you imagine that? I always threaten to go buy season tickets to the Tigers and go to every game and sit in the parking lot. Come on up here. What are you doing outside?
I'll wait for a lawyer.
Your name?
Rafael Santana.
Did you listen to and understand the rights?
Judge, we were not aware he was in here in order to show him the video. I didn't know he was in person.
You have the right to a lawyer. You have the right to proper venue. You have the right to apply for funding. You have the right to a jury trial. Do you understand all those rights? Do you wish to speak to a lawyer?
No.
You intend to apply for funding?
No.
Mr. Bapacker, you want to tell me how much is owed? Just the total sum.
Yeah, the total sum is $4,961.56.
Do you agree that you owe that amount?
The amount that I got was 3,800.
Are you including January rent?
Yes, Your Honor.
I'm asking you.
No, I'm just including what they said.
All right. Well, you got to include January rent. How much is January rent?
$1,110, Your Honor.
Then they've got you somewhere in the neighborhood. Give me your breakdown if you would.
Yes, Your Honor. At the time we filed the complaint, the rent to retain was $3,851.56. We added the $1,110, which brought me to the $4,961.56. And then if you add in statutory costs and attorney fees of $156, my grand total is $5,117.56.
Are you charging any late fees?
Not in the past, yes, but not for January.
No, I know, but how much in the past?
Hold on. Actually, Your Honor, my client, I don't have a ledger. My client acquired this property, and that was the rental balance owed at the time of acquisition.
Just want to make sure there's no late fees.
Yeah, there's no late fee that was added by my client for December or January.
Well, this has more than those months.
Correct.
Were you being charged late fees prior to that? I'm gonna need you to check on that. I capped them at $70. If you're sure that they're no more than $70.
The late fee spoken to is $50 for the.
All right, so good enough. Do you agree that you owe this amount? Can you pay that?
I got laid off a couple months ago and it's been hard finding work.
When can you pay this?
If I could have 2 weeks, that'd be perfect.
You can pay it all by then?
Yes. I just started working, so my checks are coming in. My wife started working. What else are expecting to be coming in too?
You're sure you can pay it all in 2 weeks?
Yes, sir.
Okay, counsel, the writ date is going to be January the 27th.
Okay.
So you have to pay by then or you have to vacate. The amount is $511,759. Do you understand that? Do you have any questions for me? All right, good luck to you. I hope you can pay that. Good luck.
Thank you, Your Honor. I'll upload a judgment. Have a good one, Mr.
Yeah,
Simpson.
make sure you send it over this morning, will you please?
I will. I'll get it done as soon as I'm done with my next hearing.
Thank you.
Thank you. Bye-bye.
Tanglewood. We ready on Tanglewood? Tanglewood versus Rosemary McCaskey, 2505195. Is Rosemary McCaskey out there, Jennifer?
No, Your Honor, I've not had her check in.
And service has been accomplished?
Yes, Your Honor.
Who's
But
here from Pal?
They're coming in. It's just taken a second for them to join.
Okay, no problem.
And we can, Miss Brown, I'm changing her name right now, but she is out from the video as well.
I'm sorry.
I will call her next. Who is here for Pallets' office? Do I have somebody here from Tanglewood for Tanglewood?
Yes, Your Honor, Sanchez, on behalf of the plaintiff.
Good morning. And Rosemary McCaskey is not here, right, Jennifer?
That is correct, Your Honor. She is not checked in.
Service was accomplished,
Service
right?
was with tact and second mailing.
I'm gonna go ahead and let Mr. Engel represent me
Okay.
because we had to understand about some things, so I'm gonna let him represent me on this matter.
All right. Do we need the jury or not?
Mhm. There you go. Yeah, we'll take the jury.
Okay. Do we have the jury ready? Do we know? Are they checked in? Okay. So we need to change Mr. King out into some civilian clothing. So let's go ahead and take a break. And it looks like all our jurors are here. I haven't seen a seating chart or the questionnaires yet. I'm sure they're on the way. So let's get Mr. King changed out and plan on starting in 10 minutes.
I'm ready whenever you are,
Does
Judge.
that work?
Ready whenever.
All right. Anything preliminary to come to my attention? We talked about some stipulations and so forth. Where are we at with that?
Yeah, yes, Judge. Ms. Tranter has provided some stipulations, and I think we're good on these. They're just to stipulate essentially for the admissions of medical records for both Mr. King and the alleged victim, some surveillance videos, also stipulating that the incident occurred on the grounds of a state correctional institution, the victim's an employee of ODRC, and the defendant was incarcerated at the time.
Okay. Anything else?
What did I do? Oh.
So, I'm okay writing that in my hand. I can hand that up to the court.
Yep. That's fine. Yeah, thank you.
Sure. One other thing, Mr. King.
Yeah.
And there's no good way to broach this subject. And honestly, I don't like talking about it. But one of the things that is going to come up at the trial when we do jury selection is we have something called a Batson challenge. You know what a Batson challenge is? Essentially what that means is that if the defendant is a person of a minority race and there is a juror who is the same race as the defendant, the Batson rule is that in order to excuse that juror on a peremptory challenge, the state of Ohio has a higher burden to establish that their reason for excusing that person is race neutral. Do you sort of understand that?
Yeah.
So in order to do that, I have to ask you what your race is. And I don't like that because I don't want you to think that I am making any decisions about what your race is, but I need to have on the record what your race is. Because as you will see from the jury instructions, if you're looking over Mr. Engel's shoulder, the race of the jurors is already listed on the questionnaire. What race are you, Mr. King?
Jamaican, black.
Okay. All right. Anything else preliminary before we get going?
No, Your Honor.
No, Your Honor.
All right. Let's get them changed out. We'll see everybody back here at 9:45.
Take out the parts that I wasn't, the delays not attributable to me. It was relatively quick.
Everything is attributable to you.
Fair enough.
Good morning, Mr. Vincent. How are you?
Back there, talking to Dr. Kaplan, revisiting all the old times we had together back in the 90s.
I was 3.
How
come everybody laughed?
Well, I was 33 then.
Yeah.
I'm not gonna lie, that's a lie big.
Yeah, that's it. Bring you out? Yeah, we can bring you out. Court does call the case of the people of the state of Michigan versus Marvin Sullivan.
And Your Honor, good morning, Jonathan Emmons on behalf of the people. Good morning, Your Honor, Michael Vincent on behalf of Marvin Sullivan.
All right, this is a continuation of the preliminary examination. Are people ready to proceed?
We are, Your Honor. I've got Dr. Kaplan out in the imaging room. He's going to be my first witness, and Ms. Washington is here. I just wanted to inquire, her attorney suggested that he was going to be present via Zoom. I just want to.
He's not signed in.
Okay.
So you're calling the doctor first, however. Okay. And maybe just get a note to Ann. She's probably listening to check with the attorney's office. I know there was a medical issue, which is why he was appearing via Zoom, but we'll figure it out. All right.
Okay. I'm going to go grab the doctor and start with him. Oh, never mind. Thank you.
Doctor, if you please come forward and be sworn.
Take a seat, raise your right hand. Can you solemnly swear to affirm the testimony about here, truth, the whole truth, and nothing but the truth, so? I do. See, stage first and last name.
My name is Michael Kaplan. First name is spelled Michael. Last name is Caplan.
All right, may inquire.
Thank you. We've got your name. What's your current employment?
My current employment is at the New York City Office of the Chief Medical Examiner in Manhattan.
Okay, and how were you employed back in 2021?
In 2021, I was employed at the University of Michigan Health System in the Department of Pathology, and also as a deputy medical examiner for Washington County.
Okay, and speaking about that deputy medical examiner, how does one become a medical examiner? Why don't you lay for us some of your educational background?
Sure. So to become a medical examiner or a forensic pathologist, started with an undergraduate degree at Michigan State University. Science, which is basically science applied to matters of public health and public safety. After that, I went to medical school at University of Connecticut, gained my MD degree in 1987. I then did a 5-year residency in pathology, which is the study of how the human body reacts to disease. And that was from 1987 to 1992. From 1992 to 1993, I did a fellowship in forensic pathology, which again is pathology applied to matters of the public interest, public health, and public safety. That was at the New York City Office of the Chief Medical Examiner. And then I did 1 other year in pediatric pathology, which is the study of diseases of children, infants, and unborn fetuses. And that was at the University of Pittsburgh Medical Center.
After the University of Pittsburgh Medical Center, then do you then become a medical examiner or a forensic pathologist?
Yes, I was actually a forensic pathologist after finishing my fellowship in New York City in 1993.
Okay, all right, thank you. And at some point in time, though, you eventually come back to the University of Michigan.
That's
or come to the University of Michigan. And how long are you at the University of Michigan?
I was at the University of Michigan for 5 years, 1993 to 1998.
And then obviously this happened in 2001, 2021. How do you come back in the 2020s back to the University of Michigan?
So after finishing, after working at the University of Michigan, then I took on several other jobs in forensic pathology. I worked at the state of Delaware as a medical examiner from 1998 to 2003. I worked at the Medical University of South Carolina in Charleston from 2004 to 2008 and from 2011 to 2014. Also did some private practice in pathology in Northern Michigan from 2008 to 2010. Then from 2014 to 2020, I was chief medical examiner in Suffolk County and Long Island. And then in November of 2020 was when I came back to the University of Michigan and Washtenaw County.
In all of that experience, Have you ever had the occasion to do a post-mortem examination or an autopsy, as it might be called, or any other similar type of terminology in any of the other states?
Yes, I have.
And how many would you say that you've done over the course of your extensive career?
I can't give you an exact number, but I would estimate that somewhere between 2,500 and 3,500, somewhere in that range.
Any of those involving gunshot wounds?
Yes.
Have you ever testified in court previously?
Yes, I have.
Have you ever testified as an expert in the field of forensic pathology or something similar to that?
Yes, I have.
Okay. You've ever been qualified as an expert in that field? If I just didn't ask that question.
Yes, I have.
Okay. Your Honor, at this point in time, unless there's any objection or voir dire on the issue, I'm going to move to admit his testimony on the basis of that of an expert.
Okay.
In the field of forensic pathology.
So qualified.
Thank you. Turning your attention, while you were at the University of Michigan, did you perform an autopsy on a Daryl Banks on or about June 16, 2021? And just to remind you, Daryl is Deryl.
Yes, I performed that autopsy actually on June 17th.
Thank you. Can you walk us through the process that you perform when you perform a postmortem examination?
Yes. So when we perform an autopsy, and an autopsy comes from the Greek word, which means to see for yourself. So in an autopsy, a pathologist is seeing for themselves what diseases or injuries caused or contributed to the death. So the autopsy starts with what we call an external examination, which is an inspection of the entire surface of the body, including any clothing that may be present. It would involve, basic descriptions of height and weight, hair color, eye color, and then includes any distinctive skin lesions like moles, any distinctive scars, any tattoos or other identifying features, any items of therapeutic intervention such as tubes or lines or incisions, and then any injuries that are on the body. And that's the external examination.
And after the external examination, how does one proceed next?
The next part of the autopsy is what we call the internal examination. And that consists of a Y-shaped incision that's made starting from the top of the shoulders, down to the midline, to the bottom of the breastbone, all the way down to the pubic bone, and then the skin and the soft tissue to hold it away. That exposes all the organs in the abdominal cavity, such as the stomach, the liver, the spleen, and then tools are used to take off the front of the rib cage, and that's going to expose the chest organs such as the heart and the lungs and the windpipe. All of those organs are moved, they are weighed, and then they are examined for any injuries or diseases. Also including in the internal examination is an examination of the head and the neck. For the head, an incision is made in the bones behind the ears, called the mastoid. The incision, then you bend the scalp back and forward, and that exposes the skull cap. And then the circular saw is used to remove the skull, and it exposes the brain and its coverings. Again, brain and coverings remove bleeding and any other injuries, diseases. And then the last part of the autopsy is the neck, and that includes the muscles of the neck and the larynx, the voice box, and the trachea. And those are also.
What about tissues and toxicology?
Yes. So part of an autopsy also is to remove samples of tissue to look at under the microscope or to preserve in case examination might be necessary later. And also part of standard autopsy is to obtain samples for toxicologic examination, and that can include blood, urine, liver tissue, and other tissues as is dictated by the case.
All right. And did you follow that process as it relates to that June 17th examination with Mr. Banks?
Yes, I did.
And what observations, starting with the external examination, what observations of any injuries or defects did you note during the external examination?
So I noted that Mr. Banks was a well-developed, well-nourished person. He looked consistent with his stated age of 35 years. He was about 5 feet 8 inches and weighed about 170 pounds. He had brown eyes. He had black hair up to about 1.5 inches. He had a connecting mustache and a beard. Really the only skin lesion he had was a small little mole on the bottom of the right eye area. There were no scars or tattoos that I observed on him, at least anything distinctive. He had multiple items of therapeutic intervention, which included a tube in the mouth that went into the windpipe for trachea. He also had a tube in the mouth that went into the stomach. He had vascular lines that were 2 in the groin. There was also one in the forearm and then one on the back of the left hand. He also had.
I'm going to stop you right there. Those tubes and lines that you described, those are something that's consistent with emergency medical treatment at a hospital.
Correct.
Okay.
Therapeutic intervention.
Yes, perfect. Thank you. All right, go on. So you noticed the tubes. Anything else that caught your attention?
Yeah, the other thing was that he also had a tube that was put in the chest, on the left side of the chest, at about the level of the nipple, and that was attached to a drain that contained about 1 liter of bloody fluid.
Okay.
And then there was also also an incision that was going across the chest right from the midline all the way to the back of the armpit area. And then there was one other incision that was about 21 inches long that went down the middle of the abdomen.
Okay. Did you have any observations about whether he had suffered any injuries that led to those medical interventions?
Yes, I did.
And what were those?
I observed 3 gunshot wounds on his body. One was to the left side of the chest, a little bit behind the midline where the armpit is. That was about 21 inches below the top of the head. And that was an oval perforation that was consistent with an entrance wound.
Mm-hmm.
I also saw an exit wound that was on the right flank region, which is below where the rib cage is. And that corresponded to the entrance wound on the left side of the chest. I also observed.
Hold on just a second. And Your Honor, for the record, he's pointing to his left side for the entrance wound and in the right side for the exit wound. Thank you. Go ahead. I'm sorry.
I also observed an entrance wound on the side of the left thigh that was about 25 inches below the top of the head. And that was also an entrance wound. And then the other entrance wound that I observed was on the right side of the back, about 21 inches below the top of the head and about 2 inches to the right of the head.
Okay. When you say top of the head of
his head.
Of his head. Okay.
Those are anatomic landmarks that we use to designate the position.
Right. Okay. I wanted to make sure it wasn't the head of the hip or some other.
Yeah,
okay.
The head of the skull.
All right. And do you know when you perform this autopsy examination, is it uncommon for officers to be present with you at the time that the examination is being performed?
No, it's not uncommon. It's common.
Do you recall there being a detective or officer with you during the examination, Mr. Banks? I know this was some time ago.
Yes, I do.
Okay. And I've previously furnished to you several pictures that were taken of that examination. Do you recall? You received those prior to today's testimony, correct?
Yes, I do. I'm
going to hand what's been marked as People's Proposed Exhibits 21, 22, and 23. You got them? Okay. If I may approach, Your Honor?
Yes.
Dr. Kaplan, I'm going to ask you to just review each one of those 21, 22, and 23, and let me know when you've reviewed them. Those pictures that you reviewed, are those pictures of Mr. Banks as he was at the forensic autopsy or at the forensic examination, the autopsy, the postmortem?
Yes, they are.
And I'm sorry, and where did that postmortem take place at?
That postmortem examination took place at the University of Michigan Medicine Autopsy.
Okay, but that's not where he was treated at, obviously.
That's
Do you remember what hospital he came from?
I don't remember.
Okay.
Offhand. I may have it in my report, but I don't recall.
It's not terribly. Okay.
Yeah, St. Joseph Mercy Hospital.
Now, you might not know this, but Trinity Health now.
Okay, Trinity.
Okay. Thank you. Those pictures that you have in front of you, are those fair and accurate copies of Mr. Banks's body as you received it and examined it on the 17th of June, 2021?
Yes, they are.
Thank you. Your Honor, unless there's any objection or voir dire on each of those issues, I'm going to move to admit people's 21, 22, and 23.
Any objection or voir dire?
Your Honor, can I preserve my voir dire, my cross-exam?
Yes.
Thanks.
So I will not admit them at this point.
Okay, I'll remove at a later time then, the court's permission. Okay. If you don't mind though, if you could, referencing those pictures, can you show the judge each one of those wounds that you were talking about, or explain to the court what each of those injuries are?
Yes.
And then just please reference, I've got each of those labeled. If you could just please reference the exhibit number.
So starting with exhibit 21 here.
Yes.
Okay, this is the right, we're looking at, this is a profile view, we're looking at it at the right side of the body of Mr. Darrell Banks with the identification of the Washington County number. This is the exit that's been sutured. That represents the exit of the entrance wound that I had described on the left side of the chest. This is a contusion or a bruise around that exit. From the force of the bullet. You see there's also a sutured incision in the midline of the abdomen. You can see a line in the right groin. And then there's also, you can see some lines coming from the mouth area, as well as a vascular line from the right elbow.
Any exhibit, I'm sorry, did you go through exhibit 22 and 20?
Exhibit 22 is now we're looking at the left side of Mr. Darrell Banks' body, also the identifying case number. What we're seeing here is at the top, this is that left-sided incision. Okay, yes. We call a left thoracotomy, opening up the chest, going from the midline all the way to the back of the armpit area. Immediately below that is where the chest tube was inserted.
Okay.
And at about the level of the nipple. And that's attached to a drain that has about a liter of bloody fluid. And then below this right here, this is the entrance wound on the left side of the chest that was about 21 inches below the top of the head. And this was the one that took a path across the abdomen and was represented by the exit wounds in exhibit 21.
Your Honor, could you ask the witness to hold so I could take a look at them, make sure we're talking about the
That's exhibit 21.
21, yeah, got that.
And this is exhibit 22.
Thank you.
And then finally, exhibit 23, I think you still have in front of you as well.
Yeah.
This is
the back side of 23. I'll show you, Ron. So now what we're seeing, actually, we can see all three entrance wounds. We can see the entrance wound on the left side of the chest, which you saw in exhibit 22. We can now see the entrance wound on the outer margin of the lateral part of the upper buttock region. And we can now see the entrance wound on the lower right side of the back.
Got it. Okay. Your Honor, could the witness hold the picture up and point at what you just testified?
Yes. So this is the entrance wound on the left side of the chest, slightly behind the armpit region. This is the entrance wound on the outer margin of the left buttock. And this is the entrance wound on the right side of the lower back.
Thank you.
Thank you for that. You've made your external examination. I assume then you did the internal examination.
Yes, I did.
And when you did the internal examination, did you find any evidence of damage, obviously, to the organs and body of Mr. Banks?
Yes, I found evidence of both injury and therapeutic.
Okay. What types of injuries were you able to sustain to happen to the inside of Mr. Banks?
So the injury, the gunshot wound to the left side of the chest took a path through the skin and the soft tissues. It went into the space between the left 9th and the 10th rib. Then it went into the left chest cavity below the lung. It went through the diaphragm, which is the muscle that separates the chest and abdominal cavities, important muscle for breathing. And then it went into the abdominal cavity and went across the abdominal cavity, injured organs on the left side of the abdomen, spleen. It injured the stomach. It injured the first part of the small intestine called the duodenum. It injured an important artery that supplies blood to the duodenum called the gastroduodenal artery. And then it went across the abdomen and then exited on the flank region, which is below the rib cage on the right side of the body.
I'm sorry, you said that it went through. You said that it damaged several organs. You said that it went through the diaphragm, though. Is that to say that it damaged the diaphragm as well?
Yes, it did.
Okay. Okay.
So that was the path that it took.
Probably a good point in time for me to ask the difference between a penetrating versus a perforating injury, if there's a difference.
Yes.
If you could explain that.
Sure. So we use the term penetrating versus perforating to distinguish whether if a wound perforates the body, that means that the bullet or projectile passed through the entire body. Also, what we call a through and through.
Through and through.
Penetrating is when the bullet enters the body but does not leave the body.
Okay.
So a bullet or fragments of the body.
So we saw one perforating injury enter from the left side and exit out the right side, the through and through. But you also described that there were two other bullet holes. Can you tell me about what damage, if any, those wounds had inflicted upon Mr. Banks?
Do you want me to finish describing the injury on the first?
Oh, I'm sorry. Yes. I thought you had already gone through it all.
So that was associated with the wounds that first wound was associated with repairs of those perforations in the stomach.
Yeah.
And the small intestine, as well as ligation, meaning constriction of the artery, that gastroduodenal artery. There was also approximately 2 liters of blood that had been evacuated from the left chest cavity.
And how significant is you said that there was a liter that had, the one tube had drained into about a liter, and then now 2 liters. How significant is that in terms of our body mass of general humans? Is that a significant amount of blood?
Yeah, that's very significant. That's a life-threatening amount of blood loss.
Okay. All right. So now we've talked about the through and through, the damage that it's inflicted, and how evidence of repair. What about the 2 other injuries, the left buttock versus the mid back?
Yes. So the wound on the left buttock was right on the lateral border of the buttock. It was a little bit lower than the chest wound. It was about 25 inches below the top of the head, and that wound took a path through the skin and soft tissues and what we call the gluteal muscles, the buttock muscles. It then went through the iliac bone and then went into the front cavity of the hip bone called the iliac fossa. And then that took a path from left to right and ended up in the pelvic region, where it also injured the bottom part of the colon, the sigmoid colon, as well as the bladder. And that's where I recovered one of the bullets, which was a jacket bullet.
Okay. And well, I'll come to that later. That's the wound from the left buttock.
That's correct.
Okay. What about, I know that you mentioned that's the first wound, but let's be clear, you can't tell which wound happened in what sequence. Is that correct? Okay.
Yeah, when we give numbers to bullets, that those are for organization reference points. there's no reference to a chronologic sequence there.
Perfect. Thank you for that clarification. So let's talk about the final wound, if we're going to talk about the mid-back, if I can call it that.
Yes. So what's listed as gunshot wound number 3 in my autopsy report is the wound to the right side of the lower back. This was about, it was approximately just to about 22 inches below the top of the head and about 2 inches to the right of the midline. This wound took a path through the skin and the soft tissues and the connective tissue that we call the thoracolumbar fascia, just a fancy name for the deep connective tissue. It then went through the 12th rib, and then injured the kidney. It then injured the cecum, which is the first part of the large intestine. And then it grazed the bottom inferior surface of the right lobe of the liver, but did not exit the body.
So you need to turn around. Go ahead.
I'm sorry.
Go ahead, Dan.
You were talking about the liver?
Yes. So I was describing the path of, through the right 12th rib, the kidney, the first part of the large intestine, the cecum, the bottom of the liver, and then I recovered that bullet in the soft tissues of the abdomen, slightly below the rib cage. Also a non-jacket, also a jacketed.
A jacketed bullet. And that's to say that at that point in time, the core and the jacket would still all be relatively intact.
That's correct.
Okay.
And also to emphasize that at that time, the right kidney was not there anymore. It had been removed through surgical intervention, but the path that took was directly in the anatomic region of the right kidney would be.
I assume that when you're performing the examination, you also have some form of records of what interventions were given to the decedent from the hospital.
Yes, we do.
And so that would alert you that he had already had his kidney removed.
Correct.
Okay.
In addition to the midline incision,
right?
Yeah, knowing that something there has been at least an exploration.
Would you have taken X-rays of Mr. Banks at the morgue?
Yes, I would.
Okay. I'm going to approach with what's been marked as People's Proposed Exhibit 27. This is the X-ray picture.
Oh, yeah, thank you.
If I may.
Marked as 27.
Yep, I'm skipping ahead.
I realize that.
I figured this might come out a little cleaner than I anticipated. I've marked that as People's Proposed Exhibit 27. Do you recognize that item?
Yes, I do.
Okay, and what's that a picture of?
This is an X-ray showing the spine, the femoral column, femur bone, and also showing 2 bullets that represent the bullets that I recovered from Mr. Banks' body.
Thank you. I'm going to move to admit unless there's any objection or voir dire.
I'll stay here.
Okay. Okay, and exactly that. It is what it is. It's where you had described that near the entrances and the of each of those other injuries.
Now,
okay.
Just to clarify, this is a lateral. So this is showing where it is front to back. It's not showing where it is horizontal or the front. It's not showing left to right. It's showing front to back.
Great, thank you. And then finally, you said that you recovered each of those bullets.
I did.
Thank you. I'm going to approach with what's been marked as People's 24. And then this is 25. If I may approach?
You may.
Thank you. Thank you. Dr. Kaplan, I've handed you People's Proposed Exhibits 24 and 25. Do you recall each of those items?
Yes, I do.
I don't anticipate that you could maybe even be able to.
All right, you can go ahead and give me your breakdown. I'll give you a default.
Sir, based on that, please speak an entry default possession judgment. The rent to retain is $1,299.09. Cost of $189.79 for a total balance of $1,488.88 with a writ to issue after 10 days.
Do you have a breakdown on your late fees?
Your Honor, I do not.
I need to make sure that they're $70 or less per month.
Correct, Your Honor. The late fee is only $50.
Okay. Okay, so if you come in front of me, I don't know if I've had the pleasure before. If you can just give me a breakdown on the late fees, that would be helpful going forward. I'll give you a judgment, 1488.85. The writ date will be on January the 22nd, okay?
Thank you, Your Honor. I'll be prepared next time.
You're fine. You're fine. It's nice to see a smiling face for a change on this end. Thank you. Slats Enterprises versus Amy Brown, 2505287. Ms. Brown, good morning. You have to unmute. Tell me your name. Ms. Brown, there you go. Unmute.
Yes, sir.
Your name?
Amy Brown.
Did you listen? Mr. Sims, I'm sorry. Go ahead.
Oh, that's okay. Good morning, Your Honor. Mike Sims up here on behalf of the plaintiff Slats Enterprises.
Ma'am, did you listen to and understand the rights?
Yes, I did.
Do you wish to speak to a lawyer?
I would like to, yes.
Do you intend to apply for funding?
Yes, I have applied for funding. I'm waiting to hear back.
You applied for funding? Ma'am?
Yes, through the state, through MDHHS. Yes, I did apply
Good. We'll adjourn it to January 27th at 11 a.m. She's going to chat with you. You have to provide us with proof that you made application for funding within 5 days. You have to bring it up here, okay?
I got to bring it up to you. And what was the date on that you said, sir? I'm sorry, it cut out for a second.
That's all right. January 27th at 11 o'clock in the morning. And she will chat, tell you where you have to call to speak to a lawyer, and I'm adjourning it to that date, okay?
Okay.
We need proof of the funding within 5 days. You understand that?
Yes.
I'm sorry, Mr. Sims. Go ahead.
I apologize, Judge. I didn't mean to interrupt you. I just wanted to make it just to state this since I have Ms. Brown here. Since we filed this for the rent due, the complex has received numerous complaints because of her guests and other occupants pounding on people's doors, going through people's trash. It's been a real problem beyond the rent now is a main issue. So I either would like Ms. Brown to call me or for us to address that in the interim, because things are not going well at this time.
How long has this been going on?
I got an email the day after Christmas from my client about some larger issues that had taken place at the property. There were things prior to that, but it was I think it was one of the other occupants who was loitering in the common areas and making other tenants feel uncomfortable, from what I gather. But it's become a larger issue since Christmas.
What, with parties or what?
The specific language used by the client was, there's smoking, there's loud, there's people pounding on other tenants' doors. There was an elderly client who contacted my landlord, I think on Christmas or just shortly after, about someone's pounding on their door trying to get in. There's been smoking and people loud and hanging out in common areas that are not tenants that don't belong there. So there's a concern.
They can't smoke in the common areas pursuant to the lease?
It's no smoking.
So, ma'am, I'm not being accusatory here, please. I don't want to go into this. I'm just telling you, you need to be considerate to other tenants, and that includes not inviting people over if they're going to pound on doors. Ma'am, is there somebody else there?
No, sir, I'm sorry.
All right. That includes not allowing people to smoke in common areas, not allowing people to pound on other people's doors, not allowing other people to be loud. Okay, will you please do that for me so we don't have big problems?
Absolutely, I will do it. And I have talked to the people that have come in at the time. Those people don't come here no more. They were just friends of mine, and I apologize up and down for any trouble that was caused by any of that or any disruption to anybody's, normal days. So I do apologize, and I will make sure that does not happen again.
Mr. Sims, tell me the total amount owed.
The total amount there,
breakdown.
The total amount, you said you don't need a breakdown, Judge?
I don't need a breakdown.
Okay. Total amount would be $3,789.50, which would include a few late, $50 late fees and filing fees.
That's fine. So you have to pay that, ma'am. If you owe that, then you should try to pay that by the time you get here. If you don't, I'm going to have to give them a judgment at some point. Okay.
So, Your Honor, there's no way I can. I'm disabled. I'm applying for Social Security disability right now. So if I could get an extension on that,
Well, you've applied for funding. You bring the proof of the funding up here within 5 days, and then we'll reconvene on January 27th. But I can't, they're entitled to a judgment within 10 days, a writ date within 10 days of the date of the judgment. Now, if your application hasn't been decided, you're entitled to another adjournment, but you're going to end up having to pay this, and then it's going to be $4,000 and some when we get into February here.
I know.
Okay.
Oh.
All right. I'm sorry. I wish you well. We'll see you here January 27th, and that'll be at 11 o'clock in the morning. Okay.
Okay. Thank you, sir.
Honor.
Have a good day. Thanks, Mr. Sims. Woods of White Lake versus Madison Saliot and Dalton Uchtman.
Oh, we got it.
2505196. Do I have this defendant here?
John
No, Your Honor,
Capitan?
they have not checked in with us. And
Yep, John Capitan, appearing on behalf of the plaintiff.
Okay, I need you to start your video. Is Miss Saliot here or Mr. Uchtman? Either one of them.
no, Your Honor, they have not checked in, and there was
Okay.
tacking and second mailing.
Good enough. I'll give you default judgment, counsel. Go ahead.
All right, Your Honor, we move for a default judgment of possession. Rent to retain is $4,342.70. Of that, there were 2 months worth of late fees of $70 each. The costs are $232.82 for a total of $4,584.52. We asked for the writ to issue after January 22nd, no money judgment, and I'll submit this as soon as we're done with this proceeding.
Okay, good enough. Writ date will be the 22nd. Defendants failed to appear. Default judgment entered. The amount to be paid to save is 4584. That's 52, right?
That would be, hold on a second, Your Honor. Let me
Can't read my own writing.
Yeah, it's $4,342.70 for the rent to retain, $231.82 for
So 232.82, I thought. No?
Oh, no, I'm sorry, 231.82. 231.82. That leaves a
that's right.
total-
458452. You're all set.
All right, thank you. Have a great one. Bye.
Christine Investments versus Jarvis Cynthia. 2505289. Must be Cynthia Jarvis. Is Cynthia Jarvis out here?
No, Your Honor, she has not checked in. There was tacking and second mailing.
All right. Appearance, please.
Good morning, Your Honor. Grant Munson on behalf of the plaintiff.
Defendant failed to appear. I'll give you a default. I'm going to ask you to give me the principal balance, then your late fees, and then court costs.
Your Honor, I heard that earlier, and I'm trying to calculate the late fees because I don't have it broken out either.
Go ahead and pass that one. You figure it out. I'll be right back with you. How's that? FC Stratford versus Kimberly LaPointe and Don Francisco Lopez, 2505291. Appearance?
Good morning, Your Honor. David Fancher on behalf of the plaintiff.
All right. Is this individual here, Kimberly Crawford? Yes, you are. Ma'am, your name?
Kimberly Crawford.
All right. Did you listen to and understand the rights on the video?
I did.
And do you wish to exercise any of those rights? Do you wish to speak to a lawyer?
No.
You intend to apply for funding?
No.
All right. Counsel, how much is owed here?
So the total balance, and I went through, and the late fees are more than.
You to break it down for me.
Okay. Sorry, I'm just doing really.
Pass that one. Pristine Investments versus Cynthia Jarvis, 2505289. Mr. Munson, you ready?
I am. Grant
ahead.
Munson for the plaintiff. Your Honor, today I'm seeking a default judgment in the amount of $6,592.81. Of that, $500 is late fees. That's $50 a month times 10 months. The That also includes $112.04 in filing fees and $75 in statutory attorney fees.
659284.
81, 6592.
Okay, in the future, if you wouldn't mind breaking that down right in the beginning, I would appreciate it. Writ date will be January the 22nd. Again, I'm going to ask you to get that in here in the next half an hour or so. Judgment will be 659281. And again, the writ date, January 22 of 26. Are you ready on this, Mr. Pantera?
Thank you.
I am, Your Honor.
FC Stratford versus Kimberly Crawford and Don Francisco Lopez, 2505291.
Your Honor, here are the numbers. The amount of rent that's owed without late fees is $3,364.99. There's late fees of $120, which was $70 for December, $50 for January, and $229 in court costs for a total of $3,713.99.
Is Mr. Lopez there with you, Ms. Crawford?
No,
Is he an occupant of the property?
not any longer. We broke up.
Okay, so that'll be a default judgment versus him, Mr. Pantera. Do you agree that you owe 3711397, ma'am?
I agree.
All right, so
I had a loss of income and I can't afford the apartment no more. I have started moving out.
all right, so I'm gonna give him. I'm sorry.
My movers will be here on the 25th to get my furniture.
Mr.
I told the office.
Hang on. Mr. Pantera.
Yeah, I think the 25th is a Sunday. So
Yes.
I think the judgment expires on the 22nd. So, Your Honor, if you would like, I guess what you're asking is, am I willing to extend this to maybe Monday, the 26th? So
Well, yeah, go ahead.
I'm willing to do that.
January
Thank you.
26th is your writ date, ma'am, okay? So you have to vacate no later than the 26th or else a writ will issue, okay?
Okay.
I just want to make sure.
What will be issued? I'm sorry.
The bailiff's going to come out and evict you if you're not out by the 26th,
Okay.
okay?
Okay. Can I have a little longer than the 26th? Just to get the.
I can't do that, Your Honor. I mean,
Sorry, he's giving you an extra 4 days.
Okay.
22nd, okay?
Okay.
So you have to be out by that day or you're going to be evicted. I wish you well. Good luck. Thank you.
Okay, thank you.
I'll have a judgment submitted within a few minutes.
Thank you very much.
Thank you, Your Honor.
Thank you.
Hamptons versus Jana Matthews and Jasmine Matthews, 2505207. Ms. Matthews, I need your name.
Oh, Jasmine over here. Hi. I'm Jana
You're
Matthews.
sideways here. You're sideways. I need you to turn the camera. There you go. What's your name?
Jana Matthews, and this Jasmine.
Wait a minute. Slow down. What is your name?
Jana Matthews.
Okay, you were the one who appeared last time. Is Jasmine there?
Yes.
Where were you last time, Jasmine?
I was at work.
Well, you got to show up when you have a court date, okay? We didn't show him the video, right? Because she'd already seen it, Jennifer?
That is correct, Judge.
Did you listen? I'm sorry. Do you understand you have the right to a lawyer? You have the right to a jury trial. You have the right to apply for funding. You have the right to enter into a judgment or a conditional dismissal order, and you can apply for funding if you so choose. You understand all that?
Yes.
Do you wish to speak to a lawyer?
Yes, Your Honor.
Who's saying that?
Jana.
Give you a lawyer. I'm going to adjourn this to 2 weeks, adjourn this to January the 27th at 11. Now listen carefully. Do either one of you intend to apply for funding?
No. No.
How about you, Jasmine?
No.
All right, you come back here on that date, January 27th at 11. We're going to chat with you and tell you what number to call to talk to a lawyer. Counsel, what amount is owed on this case? Can you tell me?
Judge, counsel is not checked in for Freeman or for
Why not?
Hamptons rather. So
What time is your schedule?
the time for scheduled for that is 9:30, Judge.
You guys are going to have to stand by. I didn't realize they weren't here. That's my fault. You
we
guys
can- Yeah, I'll put them in a breakout room to give them the phone number, and we'll bring them back when Hamptons are ready. And then we
Sounds
are
good.
still waiting on the other ones, Judge, just so you know.
So
Okay?
don't go anywhere, you
Don't
guys,
go any-
okay? I have to call this again when the lawyer shows up, so do not go anywhere, all right? But she will chat with you or go into a breakout room with you and tell you the number to call for a lawyer. I told you when I'm adjourning this to, that's January 27th at 11, okay?
Okay.
All
Thank you,
right.
Judge.
And I don't have anything else ready?
Nothing at the moment. Nothing at the moment, Judge.
Okay.
Okay?
Good enough. Thank you.
Thank you, sir.
Okay. Let's take a recess. It's a late conference today.
Both
How are you?
Your Honor, how are you? Good to see you.
You too. Your appearance?
Rebecca Austin for plaintiff, Your Honor.
All right, I started to call this. I did call this. Jasmine and Janae, give me your phone number or give me your names, please.
Janae. Jazz.
Last names.
Matthews.
Last name. Janae.
Matthews.
All right. They're not applying for funding, but they did ask to speak to a lawyer. So I'm not going to be here next week. So we're going to adjourn this to the 27th of January at 11. And you can tell them the total amount that they owe, if you would, please. I don't need a breakdown right now.
Yes, $670.25, Your Honor.
Ladies, pay that and the case will be just dismissed. Okay? You understand that?
Yes,
Guys,
Honor.
come on, you got to talk to me.
Yes, we understand that, but we don't agree with the amount.
How much do you think you owe?
I don't think we owe anything.
You think you paid this in full?
No, those fees are.
Ma'am, just please listen to me. The greatest, easiest thing about math is there's only one right answer. So you can't say about, or I don't know. If you don't know anything, that's fine. You guys can figure that out. If you do owe something, I need to know to the penny how much you owe.
I don't think we owe anything.
Did you pay January's rent?
Yes. Yes.
Miss Austin?
They did, Your Honor. I'm sorry, I just got kind of pulled into this last minute. It appears that there were some prior court filings. So there's some court costs of $146.43, which is our cost without the statutory attorney fee. So they did pay January rent, but it looks like there's some court costs going back into.
But you can't add those in, can you? I mean, if they paid it and you guys dismissed it, is that what you're telling me?
Well, I didn't add this. No, I didn't. Well, I'm telling you, I added the cost of filing the case prior to the hearing. So there's no statutory attorney fee charge because we did not come to court because we dismissed. But the actual charge of filing the summons and complaint, getting them served, doing the second mailing, that I do pass on, Your Honor, because I did incur that expense, even though they would.
Yeah, but why are you guys dismissing the case then?
Because they paid prior to the court hearing.
Yeah, but they didn't pay in full with the court costs.
Yeah, I don't. Again, Your Honor,
Why don't you guys talk? You come back January the 27th.
Judge, we can have them come back at 9:30 on the 27th, if that's okay with you.
I've got court to school. Is that going to be good enough?
From what I am told, yes, that should be fine, because that was their only
9:30
one
on
that
that
day.
date, you guys.
Perfect. Thank you, Your
9:30,
Honor.
January 27th at 9:30. Make sure you change the time, okay?
Perfect. Thank you, Your Honor.
Thank you. Have a good day. Bryant Allen Kinney, 25B-148-464. Detective, your name?
Detective Platt, Brownstown Township Police Department.
Counsel?
Good morning, Judge Mazengate, current back Mr. Kennedy with this with Zoom.
All right.
We agree to go.
Not guilty, please entered. Has he been printed yet? Your name, sir?
Bryant Allen Kinney III.
Has he been printed yet?
Your Honor, I am not sure, but I will. Yes, he was printed last night according to him here. Yes. I will confirm that.
Where's he been?
You're talking with you?
Yeah.
Judge, I spoke to Mr. Kenny.
He walked in here before he starts giving you stories.
Yeah, I did read the ROA.
Yeah, he walked in on August 4th, and apparently we didn't get to him fast enough, where he just decided he was going to leave.
He walked in with Ms. Coates, which is one of the complaint witnesses, the judge. There was a disagreement, and then he ended up walking out. Since that time, Judge, Mr. Kenny's had a number of mental health breakdowns and a number of issues. He's been in counseling since October 2025. He's been going to counseling once a week. He currently reconciled with Ms. Coates, Judge. They are currently living together. They share one child in common, and she is currently pregnant with their second child. He's been moving around a lot since. I did update his address in the court file. And Judge, he is currently a stay-at-home dad, and he's the only one that cares for his son because his wife is the one that birthed.
Do you know anything about this, detective? I'm asking if you know anything about a reconciliation or her not wanting to proceed with charges, it sounds like.
I don't know anything in regards to this case. I'm sorry. I just know what the report has in it.
Mr. Kenny did advise me that he would. I'm sorry. But Mr. Kenny did advise me, Judge, that he would call Ms. Coates, try to have her come down and actually state that to the.
Well, he's not going to have any contact in the meantime. I'll give him a personal bond. I'll do that for him, assuming that to be the case. But you can't not show up, sir. You also have a second file here that you 25T645723 that I'm going to call. And does he stand mute on this one?
Judge, he'll plead guilty of failure on that.
Is that what you want to do?
Yes, sir. Yes,
Plead
sir.
guilty here. You could get. It looks like you could get 322, 317. You could get 32 days. Do you understand that?
Your Honor,
Sir, sir.
Just answer the judge's questions, Mr. Kenny.
Do you understand what I just asked you?
yes, I do.
You understand that?
Yes, I understand.
If you plead guilty, you're giving up your right to a hearing. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty by a preponderance of the evidence. You're waiving your right to remain silent. You don't have to plead guilty. If you plead not guilty, we're going to have a hearing. You can question their witnesses, bring in your own, use the subpoena powers of the court to bring in those witnesses and testify or remain silent as you so choose. You plead guilty, you're giving up all those rights and we won't have a hearing. Do you understand that?
Yes, Your Honor.
To the charge then that you failed to pay $317. How do you plead? Sir, talk to me, please. How do you plead to that charge?
I plead guilty.
Did you fail to pay?
Yes, I did.
Anybody forced you to plead guilty?
No.
All right, I'm going to accept your plea. Does he work?
He doesn't work, Judge. He's a stay-at-home dad. His fiance is.
When can you pay this, sir?
So
Today, we've only got $400 today, and Kimberly is on her way here with all of that money right now. And she gets paid bi-weekly. So in 2 weeks from today, she got paid today. In 2 weeks from today, I would have, another amount of money.
Judge, would the court, considering Mr. Kenny's finances, would the court be able to waive any penalties or late fees to somewhat reduce the?
Here's what I'll do. Have her come up to the court. You pay $200 today, I'll waive the balance, but the defendant still must pay the clearance fee. There's a $45 clearance fee, so have her come to the court with $245. I'll give you a personal bond on the other case. I mean, I have a little bit of hard time giving you a note based on just what you've told me, not ordering no contact.
Judge, can we move into court order no assaultive contact?
I'm gonna do that. Here, no assaultive, abusive, or intimidating behavior toward the victims. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. $2,500 personal bond. Mr. Kinney, you miss again. I'm gonna set a high cash bond. You're gonna be waiting. Do you understand that?
Yes, Your Honor.
You're gonna be waiting in jail is what I'm trying to tell you nicely. Don't do this again, okay?
I understand, and thank you very much.
So have her come up here with $245 on the civil infraction. I'll waive the balance. We're gonna give you January 28th at 9:15. Okay?
Yes, sir.
I wish you well. And have them fill out a petition for a court-appointed lawyer. Wait, don't go anywhere. What's the question?
I think he may need to call her again. Would he be allowed, would they allow?
Let him make a call and have him, you tell your girlfriend to come up here and she can pay the $245 and he's gonna release you once he gets word that she's paid the $245. So let's see, who do I have? Jennifer, can you tell Stephanie or somebody call Brownstown and ask for Detective Claft once we have the $245 and they're going to release him. Okay?
Okay.
Thank you.
You're welcome.
Thank you, Your Honor.
Thank you very much. Good luck, sir. You got to show up in court. Don't do this again.
I will absolutely be here on the 28th.
Thank you. Brenda Ice versus Bridget Ekman, 2505292.
Good morning again, Judge. Jen Wilburn, P83143 for plaintiff.
Is Bridget Ekman here? This was scheduled for 10. I give them 15 minutes. Is she here yet, Jen?
Judge, she did not appear with us.
Okay, how about Giovanni Boudry? Is he here?
They
Come
are
on
here.
up
They
here.
are on a device. Oh, yep, there they are. No.
Brenda Ice versus Giovanni Boudry, 2505293.
Jen Wilburn, P83143 for plaintiff.
Your name?
My name is Giovanni.
Did you listen to the rights on the video? Did you understand them? Do you wish to speak to a lawyer? You intend to apply for funding? Ms. Wilburn, why don't you tell me how much is owed?
Judge, there's a rental balance of $1,500, 2 late fees at $50 a month. So the subtotal is $1,600 plus the court costs, which I show as $184.17. So total would be $1,784.17.
You pay that?
Not at the moment.
When can you pay it?
I start a new job tomorrow and it's bi-weekly pay, so I'm gonna have to wait 3 weeks. But I did not non-payment. I have proofs that I did pay. I have pictures that I sent to the landlord of my money orders right before I put them in his mailbox.
When did you put them in the mailbox?
Right after I sent the pictures to the landlord. They're different pictures I have different times.
I don't know what that means. Did you send them recently, the payments?
Yes. He only accepts money orders and checks, so I do money orders and I deliver them to his, I believe it's his financial office. And put them in the mailbox. That's what I've done since I moved in.
You know anything about this?
I don't, Your Honor. Depending on when it was placed in said mailbox, I don't know when that happened. It may not have been processed.
Here's what I'm gonna do. I'm gonna adjourn this to the 27th. I want you to call up Ms. Wilburn sometime today. Give them a piece of paper, will you, John? And you call her up and you compare notes and you find out what is owed. If you guys can't agree, I'm setting it for trial. Okay? You said how much is owed, Ms. Wilburn?
I show $1,600 plus the court costs of $184.17, total
$1,784.17. And he says you say you owe nothing?
Yes. We only had, so last month was our first time going past the 15th.
You pull out all your payments. You should copy those. You should attach a ledger that tells me when you paid and how much. How long have you lived there?
It's been about 7 months.
Okay, then that should be easy to do. I'm adjourning this to January the 27th. At what time?
11 o'clock, Judge.
Do you have one already set that day, Ms. Wilburn?
I do, Judge. We're coming at 11 that date.
Okay, perfect. January 27th at 11. Okay, January 27th at 11. Thank you. Good luck. Truman Estates versus Cody Kaler, 25. Wait, Ms. Wilburn, give them your phone number.
Oh, yeah.
Absolutely. It's 734-287-3664. That's our office number. You can ask to speak to me directly.
Okay, Jen Wilburn, WILBURN. Truman Estates versus Cody Kaler, 2505294.
Jen Wilburn, P83143 for plaintiff.
Judge, he did not appear with us. This is technically the first hearing, and he was personally served.
All right, you can go ahead and take a default.
Judge, this is for possession only. The outstanding rental balance is $1,294, one late fee of $50 for a subtotal of $1,344, plus the court costs, which I show as $184.17. Grand total $1,528.17 to be paid by January 22nd.
Having failed to appear, default judgment is entered. I'm going to just ask you that you make sure you get me these judgments here early this morning if you can. Writ date will be on the 22nd.
Absolutely, Judge. I'll get them in as soon as we're done.
Have a great day. Thank you. LMV versus John Zukowski, 2505334.
Good morning, Honor. Gary Russell appearing on behalf of LMW.
Is John Zukowski here?
Judge, he did not appear with us. He was not served. I have a note here from our court officer saying he spoke to the attorney and he said he did not want to pay for the service, and that was on the 8th.
What?
Judge, I'll try. So it sounds like the process server was contacted and told that they didn't want to pay for personal service, that the mailings should be sufficient. We received a call late last week and there wasn't enough time for the officer to go back out. The defendant did not appear today, so we're going to have to adjourn it and have it served.
January 27th at what time?
11:30.
I don't know what that means. I mean, they have to go they can't tack until the third time. I don't know what that
Correct.
means. So what's he going there the first two times, Mr. Russell? Is he just going there the first two times and pretending like he wants to serve it? I don't get it. I'm not sure I understand it, but.
It's
Usually my client hires his own process server to serve.
Well, tell him to stop doing that. He can't be saying, I don't want to pay for personal service. What does that mean? He goes there the first time, the guy answers the door and he doesn't serve it? Makes no sense. None. Tell him to stop doing that. Okay?
I don't know what you're saying, Judge. No, he hires a professional process server to serve usually in most of his cases. That's why when the court called, we weren't aware of it. We thought he already had a guy going out. So we said, don't have the court officer do it because we thought he already had his professional server out there doing it.
Okay. Well, I thought she just said, I could be wrong, I can stand corrected, that the plaintiff did not wish to pay for personal service. Is that not what you said, Jennifer?
The note from the court officer says, spoke with attorneys, said wasn't paying for service. So maybe they thought that, but they didn't have a process server turn in a proof. So even if our officer was attempting, theirs wasn't, apparently.
Right. They haven't got personal service. That's correct. We only got the mailing service at this point. That's correct.
Well, I don't have a proof of service though.
No, through the requested second service to the court by mailing. We submitted that form when we filed the case.
Correct. We mailed it out, but we still need a service by personal or
tacking.
Well, yeah, for a money judgment, correct.
No, for both.
Oh, you still got to have service. It's either tacking, which requires them to go 3 times before they tack, or personal service. This isn't just mail a first-class letter to somebody and that perfects service. That's not right. That can't be done. You get what I'm saying?
I understand your interpretation, Judge. I know
it's not an interpretation. That's like 2 and 2 is 4. You can't just mail the first class letter and not have tacking or personal service and act like service is perfected. Now, if he shows up, he's submitted to the jurisdiction of the court. So he's going to have to go out and perfect service, and he's going to have to do it. I'll give you that new date, but there's no interpretation that I know of, none whatsoever, that says you can just mail a first-class letter, have the court do it, and that's good enough to be service if there's no tacking or personal service. That's just not the law. I'm sorry. January 27th, we'll see here. Thank you. Wendy Tucker Beck versus Lisa Summers and Stephen Summers, 2605336. How's that interpretation?
Yes, Your Honor.
Good morning, ma'am. Your name?
I'm Wendy Tucker Beck, Your Honor.
Do I have Lisa Summers or Stephen Summers here, Jennifer?
Neither one of them have checked in with us, Judge. Lisa Summers looks like she was substitute service, and then Stephen Summers was personally served. Both were second mailing.
Okay, so you get to go ahead and take a judgment. You got to tell me how much is owed, though, ma'am. Okay, how much is just owed in rent? Just rent.
$6,600.
Just in rent?
Yes, Your Honor.
Not including any late fees, not including any unpaid water bills or court fees, right?
That is correct, Your Honor.
Do you have any late fees?
I do not.
You never charge late fees?
I've never charged them a late fee, no.
Okay, what is unpaid water bill? Do you have any of that?
Yes, the unpaid water bill is, let's see. The unpaid water bill is $350.
Okay, so they owe $69.50. Do they owe, and then plus your court costs? How much do you have in court costs?
I have $225.81. That was for court costs, mailing fees, and
that's fine. Is it $71.75.81?
Yes, Your Honor, $7,175.
Judge, I'm sorry to interrupt, but if I may, I do see that Lisa Summers is here in the waiting room. It looks like we just let her in. Well, wait a minute. Did you let her in? Okay, never mind. Go right ahead. She was right there and now she's gone again. Carry on. I apologize.
Okay. All right, so that's the amount that's owed to you, right?
Yes, sir. I did not include all of the fees for traveling down there. I was in your courtroom last Thursday.
You can't charge travel fees.
No, but I'm also being hit with blight fines from the city because of 2 defunct motorhomes that they have on my property, on the property. And I'd like to ask for permission to have those moved. I will pay for them to be moved.
What is this for? Is this a mobile home?
Motorhomes. They have 2 non-working motorhomes on the property. And I was in your courtroom last.
Slow down a second. What are you renting to them?
I'm
Judge, she
renting
is
the
back
house
in.
to
She
them.
just popped up.
Hang on a second. Let's go back. Ms. Summers? Ms. Summers, you have to start your video. Ms. Wilburn, I'm not sure what you're here on. Do you have another one?
I do, Judge. We passed on it because it was only a couple minutes after. It was for Brenda Ice and Ekman.
Jared, can you find this for me? I don't know. It should be one of these. Brenda Ice versus Ekman. Ms. Summers, your name? Ms. Summers, your name?
Brenda, yes to that.
Ms. Summers, can you hear me? Ms. Summers, can you hear me, ma'am? Can you chat with them, Jennifer?
Yes, Judge, I just asked them to connect their audio.
Let's go to Brenda Ice versus Bridget Ekman, 2505292. Your appearance?
Jen Wilburn, P83143 for plaintiff.
Brenda Ekman is not here, right?
That is correct, Judge.
So what did I do? Did I adjourn this just because it wasn't 15 minutes?
Correct, Judge.
All right, go ahead. I'll give you a default.
Possession only, outstanding rent, $2,800. 2 late fees at $50 a month for $100. Court costs $184.17. Grand total $3,084.17 to be paid by the 22nd, and I will file that in a moment.
Defendant failed to appear. 12226 will be the writ date. Default judgment 308-417. Yeah, if you can get me those now, that would be helpful. Okay.
Yep. The other 3 were already filed.
Thank you very much with Ms. Wilburn. Have a great day.
You too, Judge. Thank you.
All right. I'm going to wait till they bring in Ms. Summers. This is the problem with Zoom.
It appears that she disconnected again, Judge, so maybe give her just a few minutes, see if she can reconnect.
What's this gentleman?
He's for 10:30.
10:30?
Yep. Okay. Sir.
Motorhomes on the property that do not work, that I am being cited
Wait,
blight
wait,
on.
wait. You're leasing property. Is that a house or what is this that you're leasing?
I'm leasing them a house, Your Honor,
And they have two inoperable motorhomes that are on your property and you're getting cited by
yes.
City of Rockwood for that, right?
Yes, Your Honor. And I'm asking today for permission from the court to have those removed so that I can
Okay, you got a
resolve the blight.
different situation going with that.
Okay.
Let me talk to them if we can ever get them in here. If not, I'm going to have to adjourn this and they're going to have to show up in 2 weeks in person. That's the only thing I can do. You don't have to show in person. You live up in the Upper Peninsula, right?
Yes, Your Honor.
I mean, just St. Ignace, but still, it's quite a haul. So I'm not going to make you drive here for sure.
I appreciate that, Your Honor. My P.O. box is in St. Ignace. I actually live about an hour away from St. Ignace.
North or south?
North west
Okay.
of St. Ignace.
Very peaceful up there, isn't it?
Yes, Your Honor, it is.
Of course, it's pretty cold and snowy up there right now, probably, right?
Yes, Your Honor, it is. Yes.
Nice place in the summer, though.
It is.
Okay, let me just see what's going on here. Have we heard
She's
anything?
back.
Ms. Summers, you need to start your video, ma'am. So I can see your face. There you go. Can you hear me?
Yes, I can.
Your name?
Lisa Summers.
Is that Stephen Summers?
Yes, it is.
And you have to state your name, sir.
Stephen Summers.
And Ms. Tucker Beck, your name again.
Wendy Tucker Beck.
All right. She is just out. First of all, did you two listen to and understand the rights on the video? Let's start
Judge,
with
they
you.
didn't see it because they've logged in and had problems.
You have the right to a lawyer. You have the right to proper venue. You have the right to a jury trial. You have the right to apply for funding if you would like with a variety of different agencies. You can enter into a consent judgment. You can enter into a conditional dismissal. You can take this to trial if you want. Do you understand what I just said, Ms. Summers?
Yes, I do.
Mr. Summers?
Yes, Your Honor.
Do either one of you or both of you wish to speak to a lawyer?
Yes.
Okay, folks, I'm going to give you a 2-week adjournment, and I have no choice in that, Ms. Tucker Beck. But she just got done telling me, geez, do we have any more whiteout? She just got done telling me that you guys owe her a lot of money and that you got inoperable motorhomes on your property.
No, my motor.
Hang on a second. She thinks that you owe $7,175.81, which consists of $6,600 in rent, $350 in an unpaid water bill, and $225.81 in court costs. Do you agree that you owe that amount?
No, I don't.
How much do you owe?
For rent, $6,400.
Okay. Is there any other of these figures you disagree with? They're entitled to court costs.
I don't agree with the water bill, because it's not our water bill. Our water bill we have in our name, and that water bill is not in our name. It was the water bill from the person that was managing this house before we took it over, got the lease, and
hang on. This is what I'm going to do.
Okay.
I'm adjourning this until January 27th.
Okay.
I'm going to adjourn this to what time, John? 9:30?
11:30, Judge.
11:30. And I'm going to tell the two of you that whether you owe $6,400 or $6,950, which would include the unpaid water bill, you still owe court costs. So you're up around $68.25.81 at a minimum.
That's why I need to speak with a lawyer.
I know, but you're gonna have a problem if you aren't able to pay that at the next court hearing. Do we understand one another?
Yes.
Okay, that's a lot of money. And she's also pointing out that you have inoperable motorhomes on your property, and now the city's after her for a violation of their ordinances pertaining to blight.
Well, both my motorhomes run and they're drivable.
Are they have valid plates on them?
I just bought the one. I haven't got it registered yet.
Well, you
but the
got
other
to
one-
get plates
the other one
on
does.
those. You got to get
Yeah.
plates on those.
I know, I haven't
okay?
had the chance to go down
Well,
and do
you
it
got
yet.
it. When did you get it?
About 2 weeks ago.
All right. What are you doing? You working a lot?
No.
Why didn't you go-
I've been very sick. So I
Go
haven't had a
get the
chance to get down.
plates. Go get
will.
the plates.
No problem,
okay?
but they haven't said anything to me.
Well, they said something to her. She's the owner. Go get the plates. Make them operable. Got it?
Okay, yep,
All
no
right.
problem.
We'll see everybody here January 27th at 11:30. If you think you can't properly log on, you're going to have to show up in person, Mr. and Mrs. Summers. Okay?
All right, thank you.
We were patient today. I won't be next time. Okay?
All
Thank you
right.
very much. Have a great day.
You too, bye-bye.
What do I have at
Thank you.
10:30? Thank you.
You have 3 and 10:30.
Is any lawyers out there for the 10:30s?
No, Your
Jennifer.
Honor, just the plaintiff on the small claims.
Oh, I got a small claims. That's nice to know. Where,
Well, that's the returning on Lessel. You had him coming back today.
all right. Can you guys hand me that file? Is the defendant here on that?
Looks
Is the
like he might be
plaintiff-
in the courtroom.
Is the plaintiff here on that?
Plaintiff is on Zoom because they're out of town.
All right, let's go. Come on up here, guys. Tony and Brenda Lessel versus Don's Home Maintenance, 2504042. Come on up.
Right to the corner.
All right. Lessels, I need you in here.
We're here.
Well, I need you to, I need to see you. You got to you got to start your video.
Okay. How do you do that?
If I may, Judge, Mr. and Mrs. Lessel, there should be a little icon of like a movie camera down in the left-hand corner with a line through it. You want to click that so the line goes
What's
away.
your name again, sir?
Donald Skritsky.
Spell your last name.
SKRZYCKI.
Here's the video right there. Okay. That didn't do anything.
And
Do you see us now?
You own Don's Home Maintenance?
That's correct.
You're the principal, the president.
Yes.
And let's just wait till they log in.
We're still trying. That's just,
There we go. We can see you now.
okay.
Okay. No, we can't. That's another lawyer. I can't
Apologies.
see.
Yep. Nope. All right, Mr. and Mrs. Lessel, we still cannot see you. Can you see the little icon with the video camera?
Yeah. Yes.
Okay.
I
Did
clicked
you?
it.
Okay.
It says unlock A26 to start your video. So we have to go to settings, I guess, and unlock something.
I suppose.
I never
Can you-
seen it. I never seen nothing being locked. Is Richard Hall here? Jennifer?
Your Honor, Judge, or I'm sorry, Your Honor, Mr. Hall did not check in with us. He's in the,
Mr. Canfor, I've got to give
you
him
know-
15 minutes. This was
He's on Zoom.
Judge, he is now logging in.
good. Mr. and Mrs. Lessel can try to connect. Mr. Hall, there you go. This is Belinda Sikowski versus Richard Hall. Have a seat, sir. It's 2505232. You can sit right at that table. Mr. Hall, your name?
Richard Hall.
Mr. Camphor?
Yes, good morning, Your Honor. Darren Canfor on behalf of the plaintiff, Ms. Sipkowski.
Mr. Hall, did you listen to and understand the rights on the video?
Yes, sir.
Do you wish to speak to a lawyer?
Everything's on.
I can't afford one, sir.
I mean, they have lawyers available if you want to talk to somebody.
Okay, please.
You intend to apply for funding?
I'm not sure. I don't know if I can or not.
Well, you can apply. The question is, do you qualify? Do you work?
I lost my job, which is why I'm in this situation now.
All right. Listen, I'm going to adjourn this to January 27th. Is that going to be at 11:30, Jen?
Yes, Your Honor.
At 11:30. Now, we're going to tell you the phone number. You can call the lawyer. Counsel, tell me the balance owed as of today. Just the total balance. I don't need a breakdown.
All right, 1 second. Sorry, Judge. I would have, let's see, 41. It was previously 4125 as of December. So add on another $1,375. So it's roughly
5,500.
5,500. Yeah.
All right. So, Mr. Hall, you're going to end up having to pay that. If you don't pay it by the next court date, I'm going to have to give them a judgment. You can't apply for funding. If you want to come up here, we're going to give you all the places that you can apply. And then you're going to have to submit your application that shows that you applied for funding within 5 days. Department of Health and Human Services, Local Coordinated Entry Agency, HERA, Federal Help for Homeless Program. You can come up here. They'll give you all the agencies you can apply with. We have a list of that, right, Jen Wiseman?
Yes, and it should have been attached to his packet he received. We always put it
should
with
be
it.
attached to your packet.
Okay.
But if you apply, we need you to submit that to us within 5 days showing that you apply. I'm adjourning this to January 27th at 11:30, okay?
Okay, thank you, sir.
Best of luck. Thank you. South Point Square versus Brandon Harris. Well, I'll see you here on the 27th, Mr. Canfor. Thank you.
Yeah. Thank you, Your Honor. Yep.
Do I have them out there, Landau's office? And do I have
No, Your
Brandon?
Honor,
Oh, we can see that.
Folks, I don't know what to do. I mean, are you coming home anytime soon?
We can see you.
Well, I can't see you and I can't handle a case if I can only see a black screen. When are you coming home?
June.
Well, I can't adjourn this to June. I mean, one or two things have to happen. I'm going to give you your choice. One or two or three things. You can either agree to dismiss this case without prejudice, Mr. Skursky. Are you agreeable to that?
Oh, sure.
And then you can refile it when you get home, but I cannot conduct it, or you can come home, fly back from Florida, I think you told me you were at, and I will handle it that way, but it's got to happen one way or the other. What did I do with that phone?
See if we can get the screen.
John, do you have that phone? Did I give you that? I keep putting them up there. Leslie versus Don's maintenance.
Judge, if I may, just so they know, it looks like their camera is locked. At least it's what it's showing on our screen.
I've seen a situation where it's locked like this. Not one time, all the times I've been doing Zoom. I have never seen that. It's Don's maintenance, Lessel versus Don's maintenance. Small claims. Did I give?
Darn it.
You have Lessel versus Don's maintenance down there by chance, you guys?
I gave Sadie all the time to his George Arnold.
She handed it to me. I called it. We can do that.
I don't know if you can, okay.
So what do you want to do, Mr. and Mrs. Lessel?
Refile. Well, we're gonna have to refile if we can't get this thing to work here. I don't understand why it's.
Jennifer, give me an order to dismiss without prejudice.
Put your phone on. Maybe it's under.
It doesn't
A
matter.
small claims case. I'm going on to the other one. South Point Square versus Brandon Harris. Stay right there, sir. 2505234. Good morning, Mr. Mudar. Your appearance?
Good morning, Your Honor. Maxfield Mudar on behalf of plaintiff.
Is this gentleman here, Mr. Harris?
Your Honor, Judge, he did not check in with us.
Yeah. I'm going to give you a default. You can go ahead and proceed.
Thank you, Your Honor. At this time, plaintiff moves for the entry of a default judgment. This is a non-payment case for possession only. We've got a rent to retain on this matter in the amount of $1,858.23. Court costs being $182.04, giving us our grand total here today.
Do you include late fees in this?
We've got late fees, but I've waived them down to the your required $70, Your Honor.
How much do you have in just past due rent? How many months of late fees?
We've got 2 months of late fees on here.
So that's 140. That means it's 17, 18, 22 in past due rent, right?
So we've got 1,900, but that's with the court costs. Removing the court costs out, we've got, 17, 18, and 19 cents.
All right. And then you got 140 in late fees and 182.04 in court costs. Your total is what?
$2,040.23.
Default judgments entered in favor of the plaintiff and against the defendants.
Thank you, Your Honor. I believe that's the only one
Date will be the 22nd. Please give me that today, will you?
Yes, Your Honor. I'll have that sent out to you in just a couple of minutes here.
Thank you. Back on Lessel versus Don's Home Maintenance, 2504042. Mr. and Mrs. Lessel, your name again.
I'm sorry, Tony Lessel.
Ma'am?
Brenda Lessel.
You guys were able to connect last time. I don't know what happened.
I don't either. I did it on my phone. But we're on a laptop.
I'll just make a note. You're not coming back to June till June. Party, and I just want to be clear. Do you agree, Mr. Skrisky, that they can dismiss the case without prejudice and refile in June?
Yes.
And you agree to that, Mr. and Mrs. Lessel?
Yes. Yes.
I'll filing fee will be waived. And then I'm going to want everybody in person when you guys do this again. You're going to have them reserved and you're going to have to pay for that. I'll just indicate cases dismissed without prejudice per agreement of the parties. And when case refiled, no filing fees. Filing fees are waived, but you'll have to pay for the service fee.
Okay, fair enough.
I call your name, please come forward. Daniel Eli. Good morning. Are you Daniel Eli? Mr. Eli, did you get a lawyer hired? Who'd you talk to? You did not talk to Raquel West because that's me.
I'm sorry. I'm discombobulated right now.
So did you write it down somewhere?
Home.
Uh-huh.
I got it on my phone. But I don't have a phone. Like Homes and Crenshaw and Lane Walker.
Okay,
There's actually a couple of more too that I can't really remember their name.
all right. So did you go visit with them or did you just talk to them on the phone?
About their price ranges and stuff.
Are you working?
Yes, now I'm trying to.
You're trying to work or you are working?
The job that I work is not like constant, but I do have a little injury today. I'm trying to get to.
Where's that?
It is retirement home. I own my something about college.
Called what?
It's, I don't know the name of it. Willie, my sister, got me an interview there.
Okay,
It's a retirement on College Street for maintenance.
okay. So where are you working a little right now?
On the port on my own Kansas.
Okay. Let's see. So you've been coming now for several months.
This is on my second visit.
Second?
Yes, ma'am.
Let me check something. All right, so what I'm gonna do, Mr. Eli, is reset your case one more time. You need to try to get someone hired before that next court date. If not, you need to visit with at least 3 others. You can tell by talking to them, they all charge different amounts and have different payment plans and things like that. You need to bring me that information, write it down, bring me who you've talked to, how much they charge, if you've gone in person, if you're just calling. I want you to actually try to get somebody hired, okay? All right, step in front of the clerk. Isaiah Tyson. Good morning, sir. You're Isaiah Tyson. And Mr. Tyson, were you able to get someone hired? Who'd you talk to?
I talked to Lord Toronto. I talked to Kent Johns. I talked to Corey Crenshaw. I talked to Whitney Holmes.
Okay, good. Are you working?
I received this.
You do? So, Mr. Tyson, you qualify for a court-appointed lawyer. I can get you taken care of this morning. Is that what you want to do?
Yes.
All right, if you'll step in front of the clerk, she might need you to sit for a few minutes and wait, or she might have that information. Okay, have a step right here and she'll let you know who that's gonna be. It is in this home. That's because you just wanted one. Kevin Kelly's. Good morning, you're Kevin Calise. And Mr. Calise, were you able to get someone hired? All right, did you talk to some lawyers? Speak up, please.
I talked to Joe Vasquez, Kelly, and Jane.
Okay. Okay, and where are you on being able to get someone hired?
I'm about to say.
I'm sorry. Y'all, I can't hear. I'm having a hard time hearing. So if I can get you all to please keep it down. Say it again.
I'm about to switch jobs because the job that I have right now is barely giving me hours.
Okay.
Maybe in about a month, I'll be able to hire someone.
Okay, perfect. Thank you for doing what I asked. I'll reset your case in normal about 30 days or so. If you get someone hired, bring this reset notice to them. If not, make sure you've talked to some others, or if you've selected one that you're going to hire and made a payment, bring a receipt, things like that, okay? Step in front of the clerk. DeMark Cole. My ears are stuffed up too, which is even worse. Good morning, you're DeMark Cole.
Yes, ma'am.
And Mr. Cole, were you able to get someone hired?
I had talked to Crenshaw, Wilkerson, and
Who?
Reedy,
Rennick.
and they were out of my price.
Are you working?
I'm trying to, I just started, but I haven't got paid or anything.
With what? With who?
Walmart, the remodeling fee.
Okay.
So
So, but you know what your income is going to be on that? what you're gonna make it per hour, kind of. So what I'm gonna do is have you fill out some paperwork this morning, Mr. Cole, to see if you qualify for a court-appointed lawyer. Thank you for doing what I asked you to. You need to fill that out accurately and completely. Just leave it all blank. Do the best you can to fill it out. You're going to swear under oath that it's all true and correct, okay? Step in front of the clerk and she'll give you that paperwork. Jorge Del Fiero. Good morning, you're Jorge Del Fiero,
Yes, ma'am.
and were you able to hire a lawyer?
Right, Kendall, I paid him 300, but he said since the charge went up, he would have to, I had to pay more.
Right.
So he told me just to get a piece of paper for them to, or for the hire him as my lawyer. Like so.
He
So
told,
here, I'll give it back to y'all, my bad.
say it
I
again.
gotta get a paper from y'all, so he can fill out and bring it back to court.
So once you make all of your payments with him, he'll file something with us that tells us that he's been hired. Did you have a receipt for what you paid him?
At the house.
Okay.
I had to reverse it.
All right, so I'm gonna, I'll reset your case about 30 days. Do you think you'll be able to get them hired in full by then? All right, so bring the reset notice that you get from us to his office so they know when that court date is when you make your payment, and then they'll tell you what to do. If for some reason you don't make all the payment in full, but you make partial payment, bring me the receipts as well, okay? Step in front of the clerk, right, Kimler. Yes, thank you. Crystal Robertson. Good morning, ma'am. You're Crystal Robertson. And Ms. Robertson, this is your initial appearance. And cause number 25 DCCR 1256, you're charged with the state jail felony offense of forging a governmental instrument from June 4th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I was in correspondence with Tanika Solomon. Shortly after the holidays, I could no longer get in touch with her, so I have a consultation meeting with Wilkerson on January 19th.
Okay, perfect. So what I'll do, Ms. Robertson, is reset your case about 30 days.
Okay.
If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Okay.
If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options.
Okay.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. She'll give you your reset notice. Lance Charbino. Good morning, you're Lance Charbino. And Mr. Charbino, since you've made bond this time, have you had an opportunity to hire a lawyer?
No, ma'am, I have not. I talked to Mr. Crenshaw once again to see if he can work with me a little bit. It'd still be $4,000 down before we can start. Talked to Mr. Wilkerson and then a Miss Robin. I forget which place Miss Robin is from. I talked to all 3 of them. I start work tomorrow, going back to the plants, making more money, so I'll be able to.
Okay, perfect. So thank you for doing what I've asked you to do. I'll reset your case about 30 days.
Yes, ma'am.
Do your best to try to get someone hired. If not, at least narrow it down to who you're planning on. If you've made any payments, bring me those receipts.
Yes, ma'am.
All right, step in front of the clerk.
Thank you.
Yes, sir. Maria Garza. Just leave it there. Thank you for that. Good morning, you're Maria Garza?
Yes.
And Ms. Garza, were you able to get someone hired?
Oh, no, ma'am, but I spoke to 3 attorneys. Renee Holmes, she's asking 5,500 and half down. And Franklin is 10,000 half down and 258. And William Marcus up to 5,000.
Are you working?
High social appointment.
Okay, so what I'm gonna do, thank you for doing what I asked, Ms. Garza, I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill that out accurately and completely. So whatever income you do have, you need to make sure and include it with your bills and all of that, because you're gonna swear under oath that it's all true and correct, and then I'll take a look at it.
And also, I have a receipt from the phone. Is that files?
Just write it all down. You're gonna get a form and you need to write all of those down on this paperwork, okay?
Okay.
Step in front of the clerk. She'll give you the paperwork. Mark Marceau. Good morning, sir. You're Mark Marceau? And Mr. Marceau, were you able to get a lawyer hired? I can't hear you. I'm sorry.
You told me to bring some papers in to show my social security.
Yeah. You can give them to the clerk. Just give it to the clerk. I'll take a look at it.
And this should be social.
All right, I'm going to find based on this that you do qualify for a court-appointed lawyer. If you will step in front of the clerk, she'll let you know who that's going to be and what your instructions are. Step right in front of this clerk. I'm going to give you a court-appointed lawyer, and she's going to tell you who that is and give you their information. Yes, sir. Thank you for bringing that.
Charles Rojas is going to remain your attorney. Okay, that's his telephone number. You have to call in and make an appointment to go see him before you come back. But sign right here and put your phone number.
Aaron Roberts. Good morning, sir. Are you Aaron Roberts?
Yes, ma'am.
And Mr. Roberts, this is your initial appearance in cause number 25, DCCR 1525. You're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from September 25th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Are you working? I need you to speak up. And y'all, I've got a, hang on a second. I've got a cold and I cannot hear. So I'm having a hard time. If y'all need to talk, I'm gonna ask if y'all can step in the back or step outside. I'm just having a really hard time hearing. And you need to speak up.
Yes, ma'am. I do some other things in the game. Pretty much the life that I got in truck loan that he said I was running from home. I had to sell it to pay the loan off for my brother so he can get me out of jail and the stuff that I got going on now. They were supposed to issue me a point for the lawyer, but.
So you have so here's the thing, you have a court-appointed lawyer.
Yes, ma'am.
But when you make bond, I expect you to at least try to hire your own attorney.
Yes, ma'am.
So here's what we're gonna do. I'm gonna reset your case. If what you're doing isn't making money, doing small jobs, you need to go try to, just listen, okay? I want you to try to either get a lawyer hired, or I want you to try to find a job so that you could attempt to hire one, okay? Before the next court date. So if you get a lawyer before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone, then again, two things. I want you to try to get a job and I want you to bring me proof that you have applied at jobs. And I also want you to start talking to lawyers so you know how much they cost and what you're trying to save up. Bring me those names of who you've talked to, how much they charge. So I know you're trying to do what I've asked you to do, then we'll discuss your options, okay? If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you'd go back to jail. You understand? All right, step in front of it, sir. Sir, come back.
Yes, ma'am.
I need a yes or a no.
Yes, ma'am.
Thank you. Step in front of the clerk.
Sign right here.
Michael Sarant.
There you go. Okay.
Yes, ma'am.
Good morning. Are you Michael Sarant?
Yes, ma'am.
And Mr. Sarant, this is your initial appearance in cause number 25 DCCR 1691. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from October 16th of 2025. Since you've made bond, have you had an opportunity to try to hire a lawyer?
I talked to one place, but I've really been trying to get a hold of the Legal Star and the Pro Bono Association, but haven't really got much friction from it.
So, I can tell you, they typically do not handle criminal cases. You were given a court-appointed lawyer while you were in custody. You still have that lawyer, but once you've made bond, I expect you to at least try to hire someone. So I'm going to reset your case about 30 days, give you some time to see if you can get someone hired.
Yes,
If you do get someone hired, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 attorneys. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice.
Thank you.
Yes, sir. Delvin Jones.
Thank you.
Good morning, sir. You're Delvin Jones?
Yes, ma'am.
And Mr. Jones, were you able to get someone hired?
No, ma'am.
Who'd you talk to?
Talk about 20 people, but I wrote down the Church Kelly Law Firm, Hecker, Trey Attorney, and Willard Law Firm, with plenty more.
Okay, so where are you on being able to get someone hired?
I'm working for Craigslist, like different gigs and trying to save up some money, so I'm just been trying to really stop.
You're working for Craigslist doing what?
Like different gigs, like, painting and stuff like that.
Okay, have you tried to go get a job somewhere else, like a full-time job?
And be a lot of stuff they kind of include your background and stuff like that. Just like Domino's, the different driver, they was gonna hire me, but they looked at my work and stuff like that.
Right. What's the status of that theft case over in Llano?
It's really about, they wanna, they say something about deferred probation. What it's gonna be pretty.
When's your next court date over there?
The 29th, I believe. They will say something about, it's not gonna be anything on my record in the case from what I was over there.
Okay, so you have an attorney over there?
Yes, ma'am.
All right. I'm going to have you fill out some paperwork this morning, Mr. Jones, to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. You're going to swear under oath that everything in it is true. If you'll step in front of the clerk down there, she'll give you that paperwork and give you your instructions.
Yes, ma'am.
Darius Sparks. Good morning, you're Darius Sparks. And Mr. Sparks, did you get someone hired?
No, it didn't go how I planned it.
Say it again?
It didn't go how I planned it. When the last court date, we started discussing about the 750 when I called back.
So here's the thing, it's been 30 days and I've probably seen hundreds of people, so remind me of what you were gonna do.
We discussed the lawyer, the law firm, Dunham Jones.
Uh-huh,
And I told them that they wanted 750,000.
right.
I talked to them again, it was $2,000. So they could do it.
Did you talk to some other lawyers then?
I talked to them, but I don't know the name. They wanted me to pay to talk to them. I couldn't pay to talk to them. I ain't have to pay to talk to them.
Right, are you working?
Yeah, I'm working.
Where are you working?
I'm working at FedEx.
So-
It's part-time.
All right, so I'm gonna have you fill out some paperwork this morning, Mr. Sparks, to see if you qualify for a court-appointed lawyer.
Yes.
You need to fill it out accurately and completely. You're gonna swear under oath that it's all true.
Yes.
Step in front of the clerk down there, she'll give you that paperwork.
Anything else?
So, Mr. Walker, you've got a Laura Adams.
Yes, ma'am.
Good morning.
How are you?
I'm okay, except that I can't hear this morning. I've got just this.
Let's stop that.
I felt like it just got worse too. It's like it just went, whoosh, you know, you get that sound.
Hearing our voices. Yeah, every time,
Yeah, y'all did it to me.
every time you'd say, I can't hear you, I'd say, do what? Yeah, my equilibrium, the whole deal. Where I'll get with the case on Miss Adams, and I think we'll have this resolved pretty quick.
Okay, Ms. Maltino's.
It's Ms. Malfino. She's not gonna be here this morning. She does have a note that she needed to have a conversation with Judge Walker about working this case out. I think they have an agreement. They just need to kind of hammer it out.
Here she comes.
Good morning, ma'am. You're Laura Adams.
Yes.
And this is 25 DCCR 0870. Ms. Adams is charged with injury to a child, elderly, or a disabled individual. And it sounds like you need a little time to visit with Ms. Malfino and get this worked out. So I'm going to reset your case, Ms. Adams. Make sure you stay in touch with Mr. Walker. He'll let you know when you need to be back. And you guys can visit about your case before then, okay? You're free to go. And you have Aaron Shetley.
I think he's right outside the door.
Aaron Shetley.
Daniel Ward.
Yep, I got it. Good morning. Are you Aaron Shetley? And this is 24 DCCR 0776. Mr. Shetley is charged with assault, family violence by impeding breath or circulation. And what is the announcement?
Gonna get into this small thing on that one too.
I know it's a little bit over, Judge, but it's the
It is.
same deal where they have been in contact, and I know that this case was originally set a week ago. They got moved a week.
Right.
And so it's another one where they're gonna have a conversation about how to work this out.
So I'll set this one. On this one, just due to the age, this will be the last reset. Make sure you stay in touch with your attorney. He's going to visit with the district attorney, and you need to get an announcement at that next court date. All right, thanks. You're free to go, sir. Daniel Ward. Good morning. Are you Daniel Ward?
Yes, ma'am.
And this is 25 DCCR 1375. Mr. Ward is charged with driving while intoxicated, third or more. And what is the announcement?
Judge, I think Mr. Nicholson should have this resolved shortly.
Okay.
I'm getting offered to Judge Walker, and we've talked a little bit this morning, but I think we're.
All right. So we'll just do a normal reset in this one. Mr. Ward, make sure you visit with your attorney before the next court date. We'll see if we can get an announcement then. Okay. You're free to go. Thank you, sir. Have a good day.
Thank you, Your Honor.
See, is there Brent Wasserstein? Mr. Wasserstein? Good morning, sir. Yes, you're here on Guadalupe Reyes. Guadalupe Reyes. How are you, sir?
Good, Judge. Nice to be here.
Good morning, sir. You're Guadalupe Reyes, and this is 25 DCCR 1422. Mr. Reyes is charged with aggravated robbery, and what is the announcement?
Judge, Mr. Washington needs to get on, it's his first time getting on
Okay.
our discovery portal, so
All
I'm
right.
gonna get him instructions on how to do that and get him.
Sure.
There's a lot of discovery in this case, and so I'm gonna get him on down the road to
Perfect.
make sure he has access.
All right, so what I'll do is just reset the case about 30 days. That'll give you some time to get all that information downloaded and go over it with your client, and we'll see where we are at the next court date.
That's great.
Stay in touch with your attorney. He'll let you know when you need to be back. You're free to go. Yes, sir. Thank you. See, is Mr. Cole here? Mr. Comerford? See, Mr. Lewis, you've got Janisha Jackson.
We are.
secretary looking for the file, I think you got this file.
Okay,
So.
I'll hold it for a few minutes. Sure.
Thank you.
And is she here?
Oh, yes.
Okay, all right, you can just have a seat, ma'am. Ms. Norman, you've got David Guillory that's set for a plea. All right, I'll sign that dismissal. Your client's free to go. Everybody's looking over like, what? Everybody's like, where's mine? We don't. Mr. Rojas, you have Christian Ainsworth. Morning. Good morning, sir. Are you Christian Ainsworth? And Mr. Rojas, will your client waive the formal reading of the indictment? Mr. Ainsworth, in cause number 25, DCCR 0275, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from February 19th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also, and it looks like the agreement that you've reached is for a 4-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the. All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Ms. Holmes, you've got Bernasha Gloston.
Yes, Your Honor.
I'm signing a dismissal that's here. She's free to go. And you've also got Christopher Ortiz.
Yes, Your Honor. Ms. Morfino paid it off. I think they were needing confirmation on what it is that was to reduce to a misdemeanor.
It is, Judge. I need to get, I got confirmation.
Okay.
Ms. Martin on that. I just need to do paperwork.
All right, I'll hold that one for paperwork then. Mr. Ortiz, just go have a seat. Ms. Holmes will go over some paperwork with you. And then you've got Dylan Wilkinson.
Yes, Your Honor. On that one, I'm not sure if y'all got it. I did it over the weekend. I have filed a motion to amend bond conditions. I printed it out just in case. And Mr. Nichols has a copy.
That's my case, Judge, and I did review it this morning.
Let me see. I kind of doubt it, but you never know.
I don't know if they've accepted it.
It's here.
You got it?
Yep. All right, sir, are you Dylan Wilkinson?
Yes, ma'am.
And this is 25 DCCR 0260, and Mr. Wilkinson is charged with deadly conduct, discharging a firearm. Ms. Holmes has filed a motion asking for me to amend bond conditions.
The GPS. And in addition to the monitor, the bondsman and the GPS company also have his phone location. So he shares his location because there was an issue where they thought he had cut his monitor, so they FaceTimed him to show that it was still on his leg. Because
wasn't showing in their system. So in addition to it, on his leg, he also shares his location with 3 other people from the company on his phone. And so because he travels a lot, it's causing issues with the job. He's a traveling technician. He's currently in Utah.
Let me look at something real quick. So I got that information about the job and I approved, as long as bondsman, he keeps them up to date. And Mr. Nichols, what's your position?
I don't really have an objection to modifying that condition, Your Honor, as long as there's a way for the bondsman to locate and contact him at all times. I have no indication there's been any issues since the inception of this case. I don't think they're in contact. It was a dating relationship issue. My understanding is they don't have any contact anymore. There has not been any issue. As long as that continues, I don't have a problem with that.
Did I or anyone make a condition of your bond that you're not allowed to have any firearms?
No.
Okay, so as of today, that's a condition of your bond, all right? So you cannot be in possession of any firearms. If you're in a car, someone else can't have one in the car. You can't be anywhere around any firearms. That's now a condition of your bond. So as long as you continue to share your location with your bondsman, then I will grant that motion, amend the bond condition for you to remove the GPS monitoring device. You know, you're definitely not supposed to have any contact or communication with the complaining witness, correct? Okay, so just continue doing what you're doing, work, go home, don't contact her, don't be in possession of any firearms, stay in touch with your bondsman, do everything they're supposed to, including sharing your location, okay? And then do we need to just reset it for an announcement, or are y'all ready to announce?
Can we have one more reset, and if possible, could we extend it a little further than normal due to him having to make arrangements to come in?
So what I'll do, Mr. Wilkinson, I'll make it a little bit longer, but we'll need to have something taken care of at that next court date. Either it's going to get worked out with the plea or it'll get moved to the trial docket. So this will be the last announcement hearing. So make sure you get in touch with Ms. Holmes, have a conversation with her before that next court date, so you know what your options are, and then we'll figure that out the next court date. So I'll do about 45 days.
Okay.
Okay?
Yes, sir.
You can go with, you're free to go, sir.
And then,
She started to say,
I know, I almost said it.
Especially when he said he had a flight.
I know. Yep, I almost said.
we're not. Yeah. Okay. But I email us. Okay. So he can go give us a link.
Mr. Parker, you have Lisa White.
She's outside, I believe. Lisa White.
Good morning. Are you Lisa White?
Yes, ma'am.
And this is 25 DCCR 0923. Ms. White is charged with aggravated assault with a deadly weapon. Mr. Parker, what is the announcement?
Your Honor, we're asking for one more reset. There's a video that I need to get. I didn't know, and I think Mr. Nichols wants to talk to the victim as well. If we get one more reset, I need her to come in my office.
Okay.
She communicates with me.
Sure.
That's correct.
All right, so Ms. White, I'm going to reset your case in the normal reset. Make sure you stay in touch with Mr. Parker so that once he gets the video and any other evidence, you can visit with him, go over all of that, and we'll see if we can get an announcement at the next court date. You're free to go. Samuel Cadena, Mr. Parker.
I have a plea, but I don't.
Okay. I saw it. She is getting those little. Mr. Cadena, step right over there for a second, please, sir.
She's trying to squeak.
Is she?
I got one. It's just we kept it the other night. It's so funny.
Is she crawling?
No, she's not due. The doctor said she'll probably be crawling too because she's starting to move her butt up and starting to push. Should push. But she says she thinks she'll walk pretty soon after she crawls.
How old is she?
4 months.
Oh, she's still little. She'll
Yeah.
be doing all that.
She's like sitting up though pretty much. Not all the way too much. She's gonna have to wear a helmet though, because from Peyton and holding her so much, hold her the same way. It's like I don't notice it, and I'm the hospital in a day and get to wear about 3 weeks.
Yeah.
Shape your head. I was like, what? I'm like, no, it's no big deal. It's just because her head's so small.
Yeah.
Okay, whatever.
Yeah, like when they're little like that, if they sleep the same way, if you hold it the same way, it'll start.
We're all attended, but I don't know. They hold it all the time, and they hold it the same way. You start changing those out. They try, and they forget. You just keep them up.
Mr. Hoffpower, this is Samuel Cadena. Good morning, sir. Are you Samuel Cadena? And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Cadena, in cause number 25 DCCR 0557, you're charged with a state jail felony offense of abandoning or endangering a child with intent to return from March 13th of 2015. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Speak up, please. Do you fully understand them? Speak up.
Yes. She's taking everything down. She can't hear you.
I can't hear you. So do you understand these documents?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal?
Yes.
And the agreement, it looks like you've reached just for a 3-year deferred probation. There would be a $500 fine, and you'll be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Also, do you understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Cadena is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. It'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you at sentencing. Sir, Mr. Peraza.
Thank you, Judge.
Thank you. On Juan Martinez. Good morning. Happy New Year to you as well. Hang on just a second. Let's get everybody up here. Good morning, sir. You're Juan Martinez.
If that's what I was going to address with the court judge, he is a Spanish speaker. If I may translate.
That would be great. Thank you, sir. All right.
Yes, ma'am.
And this is 25 DCCR 0401. And Mr. Martinez is charged with assault on a peace officer. And what is the announcement?
Your Honor, we have an agreement in principle. I just spoke with Mr. Smith this morning. He has now made a concrete offer. If we can have one setting so that I can sit down with my client, go over all the details, pertinent details, and maybe we can plead out next time. That'd be amazing.
All right, so this will be the last reset for an announcement. It looks like you been on it since last end of May. So this, we'll need to get an announcement or a plea at the next hearing. If it's not going to be a plea, then it'll get moved to the trial docket. All right, thank you, sir.
Your Honor.
Thank you. You're free to go, sir. Thank you, Mr. Smith. Mr. Hoffpower, Mr. Lewis, Mr. Hoffpower, were you able to get that file and visit with Mr. Lewis?
No, ma'am, but again, we'll have a file. What we need to do with resetting, and we'd ask to reset to make sure we print another file if you need to. I apologize, but we'll not, we have it on a computer
Okay,
to review.
I'll just do a normal reset. Janisha Jackson, Miss Jackson, you come up.
Just for the court, we'll do our best to have a copy and a copy printed out and
Whatever y'all need to do to get him an offer in the discovery. Miss Jackson, I'm going to reset your case, a normal reset. Make sure you stay in touch with Mr. Lewis. Once he gets all the information from the assistant district attorney, he'll go over that with you and we'll get an announcement at the next court date. You're free to go. Thank you. Mr. Crenshaw, you've got Timoteo Castaneda. Good morning.
Good morning. Last week, I went to go see Ashley on resolving Cody's cases since he was in trial, and now she's not here today.
Good morning. Are you Timoteo Castaneda? But this is his.
It is, but I went to see Ashley last week about resolving another case that was on the docket today that was.
Okay. I see. So Mr. Castaneda in cause number 25, DCCR 0360 is charged with indecency with a child by sexual contact. And what is the announcement?
I still do not have this resolved, Judge. And I am working with Kobe on a resolution that might include a lesser included, but we do not have that agreement yet. So I know this has been reset.
It has.
Could we just do a short reset?
It will
maybe
be
2 weeks.
2 weeks, and it will be the final reset for an announcement. So make sure you get in touch with Mr. Hoffpower, and y'all get, if there's something worked out, great. If not, it will need to get moved to the trial docket at that time.
Judge.
All right. Thank you. You're free to go, sir.
Thank you.
Daryl Hunter.
Do I need to call?
She'll get him. Thank you. And this is Ms. Malfina. Oh, thank you, Mr. Smith.
She, our last conversation was she was having trouble reaching the victim, and that's been going on for several months. And if we could also come back on this one in 2 weeks, it's my understanding it'll probably be a dismissal, but.
I don't show that she did attempt to contact her.
So let's get if y'all want to get a subpoena sent out, I'll reset it for 2 weeks to give you guys time to get that subpoena issued. And that way it might be dispositive at that next court date. So this will be a 2 week also. You're Daryl Hunter. And Mr. Hunter, we're going to reset your case for 2 weeks, give the district attorney one last chance to get in touch with the complaining witness, and then we'll see where we get at that next court date. You're free to go. Stay in touch with Mr. Crenshaw. He'll tell you exactly when to be back. And then you have Corey Richardson, Mr. Crenshaw.
And this one is a plea. Again, I was discussing the details with.
Hold on just a second. Good morning, sir. You're Corey Richardson. And Mr. Richardson is charged with solicitation of prostitution and cause number 25 DCCR 0249. Mr. Crenshaw.
Your Honor, last week I visited specifically with Ms. Molfino on this case since Kobe was in trial. I believe we're going to have this resolved with a plea agreement. If we could come back on this one as well as in 2 weeks, I'm very optimistic this one will in fact be a plea.
This isn't something you guys can take care of today since Mr. Hoffpower's here. You've been on this since February of last year. It's been a year.
We've got an offer in this case. I'm not aware. I hadn't talked to Ms. Morfino about any conversation about it. I've given her an offer before with counsel. And there was some indication they were going to speak to somebody above me.
All right.
I spoke with Mr. Giblin and he said to speak with Ashley about it, which I did last week. And she said that she was ready to make a decision, but she wanted to talk to Kobe about it first. And I don't think that ever happened because he said he hadn't talked to her.
Okay.
But
2 weeks, last reset.
this really will be a plea.
All right. So Mr. Richardson, stay in touch with Mr. Crenshaw. We'll see you back in 2 weeks.
Thank you, Judge.
Thank you, sir.
I really thought I was going to have 2 of those resolved.
That's all right. All right. We'll get them done in a couple of weeks. Let's see. Is Mr. Galmore, you've got John, is it Ferret or Foray? Good morning. Good morning, sir. You're John Foray. Speak up, please. And Mr. Foray is charged with burglary of a building and cause number 25 DCCR 1458. And what is the announcement?
Judge, we've got an offer on the table. There's 2 unfiled cases. We just need to make sure that those are either not going to be prosecuted or restitution's been considered. I believe it'll be a plea. Ms. Molfino's not here. It's her case. So if we can reset it for 2 weeks, get that sorted out.
We'll probably just do a normal reset. And I feel like I'm probably loading up already a 2-week date. If something happens and you definitely have it worked out, let us know. And if you want it moved up for a plea. Otherwise, if it's just going to be an announcement of some sort, we'll leave it at a regular.
There's a case that was received by our office almost 2 months ago, a month and a half ago. So that's what we're waiting on.
Okay. Okay, perfect. And if you'll kind of check with intake and have this Molfino check and make sure that can get taken care of before if possible. All right, stay in touch with Mr. Galmore. He'll let you know when you need to be back.
Yes, ma'am.
All right, you're free to go. Thank you. Oh, let this Phillips go. He was gonna text you, right?
To let us know. He said they were going to
At 8, so he may actually, if he's, yeah, what's in it, on Mr. Kimler's case, he's picking a jury. Kaylin Billups, Ms. Billups, Mr. Kimler is in another county and he began a jury this morning. And so we're gonna let you go, stay in touch with your bondsman in his office and they'll let you know when your next court date is. Thank you, ma'am. Good morning, Cole. Thank you. Ms. Holmes, what were y'all doing on Ortiz? Oh, okay. Okay, as soon as it comes through, I'll call it. Mr. Comerford on Ronnie Oliphant. Good morning. Good morning. Good morning, sir. Good morning. You're Ronnie Oliphant. And Mr. Comerford, will your client waive the formal reading of the indictment? Mr. Oliphant, in cause number 25 DCCR 0379, You're charged with the third-degree felony offense of injury to a child from February 18th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with your lawyer? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Oliphant's not competent?
There isn't.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at sentencing. And then you have a Simon Gobert. Good morning, you're Simon Gobert.
Yes, ma'am.
And this is 24 DCCR 0512. Mr. Gobert's charged with attempt to commit sexual performance by a child. This was the last reset. What is the announcement?
Yes, Judge, we have a forensic eval scheduled for next Tuesday. I've been in contact with Dr. Ferrara for that, and so we're just asking for one more reset to give us the report back, and then we'll be able to move forward.
Why are we just getting this done?
Well, you had signed it on December 29th or the 22nd.
Okay.
And then Dr. Farrar responded maybe 3 weeks ago and scheduled it for January 20th.
Do you have any idea how long the report for him to get that done?
Barely a week. I'll get it
Okay.
within a week max.
Okay.
Yeah.
All right, so we'll do one more reset. That should give you, just a normal one, should give you time to get that done,
Okay.
get the report. If there's anything that changes, y'all can discuss that, and then we'll come back. Stay in touch with Mr. Comerford. He'll let you know when you need to be back. Make sure you make that appointment. Don't miss it, so that we can get everything taken care of before the next court date. Okay, you're free to go. And then Jace Dunn. Thank you. Just make sure you email those attachments.
Yes.
Good morning. Are you Jace Dunn?
Yes, ma'am.
And will your client waive the formal reading of the indictment? Mr. Dunn, in cause number 25, excuse me, DCCR 0896, you're charged with the state jail felony offense of solicitation of prostitution from March 28th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Comerford?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes,
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Dunn is not competent?
There is not.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and that you understand the nature and the consequences of that plea, Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. It'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop on your way out of the courtroom and talk to probation, and she's sitting at that desk right over there. All right, we'll see you back at sentencing. Thank you, Mr. Cameron.
Thank you, Judge.
Did I see Bruce?
Darius Sparks.
Mr. Smith? He's working on some stuff. Thanks.
Darius Sparks.
And looks like Giles is working on some stuff. And then Ms. Holmes, you're working on Ortiz.
I sent it.
Okay, I'll call it as soon as it comes through.
Charles Chris before you come back in 16. Don't call him today. I know who you are, 'cause I've been in court all day. Call him in the morning, right here, call him tomorrow. Sign what your phone number for me. But just wait and call him in the morning, that way I'll have time to send you the information.
Yes.
Let's try that again. All right, again, sir, you're Cameron LeBlanc, and will your client waive the formal reading of the indictment? Mr. LeBlanc, in cause number 25, DCCR 1354, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from August 20th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Cole? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? So it only shows on here $1,000 fine.
Yes, Judge, it's standard conditions.
No, it doesn't show anything else. So what is, either it didn't come through, is there a probation?
Yes, Judge, should be
Is it-
5-year deferred.
Okay, none of that came through. It just shows the $1,000 fine and the dismissal in the county. So it's a deferred probation for 5 years?
Yes, sir.
All right, I'll fill that in. Sure. So it looks like the agreement is for a 5-year deferred probation, a $1,000 fine. There would be a dismissal as part of this agreement in cause number 25 CCCR 2146, the misdemeanor, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objections to state one, Your Honor. I know my handwriting is a little, so I know that dismissal case is 3146.
No, it should be 2-1.
2146.
What did I say?
You said 2146.
It is 2?
You put 3-1, I changed.
Okay.
Okay. All right. Any evidence that Mr. LeBlanc is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at sentencing.
Dr. Sujan.
Yes, sir. Thank you.
Sorry, Judge, you make it harder.
Oh, yeah. it was a-
That's okay. Y'all got it done.
Fabian Hall.
Your Honor, if we have an agreement for a jail sanction, do we need to do paperwork on an NERB? I never remember.
You know, because we do it both ways.
Right, I know people sometimes just don't, we have to.
What we're doing is jail as a condition of probation.
Right.
No, we'll just go through the motion, get pleas of true or not true, and then I will make a finding, because we've got to close out the motion.
Right.
So the way to close it out would just be me continuing probation and adding that condition, and probation will do the order for it, so we don't really need paperwork.
Okay. That's all good.
Okay, give me just a second, I'll call it in just a minute.
Who's on?
He's not, we're not doing paperwork.
But if they come in front of you and make an agreement,
Oh, okay. No, that's okay.
you have to prove it was that person in court.
Gotcha. Yeah, listen to her, not me.
It's a she.
She.
Sorry, never, we'll say that again too.
Good morning. How are you, Mr. LeGras?
I keep thinking when I come go, why you want to tell me you knew some of my family? Because they're all from Port Arthur here.
I don't know. And this is 23 DCCR 0167. Ms. Joseph is on probation for assault of a peace officer. There's a motion to revoke, and will she waive the formal reading of the motion? Ms. Joseph, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 11th of 2023 for assault on a peace officer, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you were arrested for the offense of driving while intoxicated with a child under 15, June 21st of 2025. But is that true or not true?
Yes, ma'am.
True or not true?
True.
Thank you. Count 2 and count 3 both allege that same offense, same date, different children. And again, are those true or not true?
True.
Count 4 alleges that you were arrested for the offense of resisting arrest or search or transportation June 21st of 2025 in Orange County. And is that true or not true?
True.
Count 5 alleges that you failed to remain in Jefferson County, Texas as directed, and that you were in Orange County, Texas on June 21st of 2025. And is that true or not true?
True.
Count 6 alleges that you were at a location other than your residence at approximately 10:17 p.m. on June 21st of 2025. And is that true or not true?
True.
Count 7 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you were arrested for driving while intoxicated June 21st of 2025. And is that true or not true?
True.
And then count 8 alleges that you are behind in your court-assessed fees as of July 17th of 2025 in the amount of $1,825. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 8 freely and voluntarily?
Yes.
And did you plead true to those counts because they're all actually true?
True.
All right.
Yes.
So I'm going to find that you entered your pleas of true to counts 1 through 8 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation. However, it's my understanding that you've reached an agreement with the district attorney's office. Mr. Nichols?
Your Honor, our intent is to have her do 120 days, day for day in the jail as a sanction, understanding that this is a rare opportunity we're waiting the resolution of her Orange County cases, that she would be on, no tolerance from this point on, and have to deal with Orange County however they see fit.
And Your Honor, she has been going out, ever since she got out of jail on her own, without any suggestion from me, she's been going to outpatient treatment 3 times a week. And she's got a job, and so I'm just gonna follow. She did that out without talking to me, just called me and said, hey, I'm getting some help.
All right, so it's your understanding that you'll go into custody, do 120 days, that you'll still be on probation, ordered to follow all the rules and conditions, including any others that I think are appropriate. Is that your understanding?
Yes, ma'am.
Then at this time, based on that, this is an excellent opportunity, Ms. Joseph, because the offense that you're on probation for, with a violation like this, you could go to prison for 2 to 20 years. So I want you to take advantage of this opportunity that you're being given today. Because if you don't, and you're back in here on any violations, it will likely not go this way. You understand? So I'm going to, again, find counts 1 through 8 true. I'm not going to revoke your probation. I'm going to continue you on probation. I am going to extend your probation by 1 year. I'm going to order the 120 days as a condition, day for day, as a sanction for these violations. I'm also going to order that you're on 0 tolerance. So when you get out of the 120 days, you have to do everything right. You need to make some payments. You're getting behind on those. Follow all of the rules and conditions. I am going to order, since you're going to treatment, it obviously appears that there's an issue. So I'm going to order when you're out that you also enter and successfully complete the JCDI program. It's an outpatient treatment program. You'll be able to continue treatment, and hopefully you won't end up in a position like this. Do you understand?
Yes.
All right, then good luck to you, ma'am. You can go with the bailiff.
Thank you, Your Honor.
Thank you. Thank you, Mr. LeGros.
Thank you. Y'all have a
We reset it. They couldn't find that file. They're having to recreate a file. The DA's office is. Yes, ma'am. See, Mr. Smith on Brian Barrier, I probably did not say that correctly. Good morning.
Did you do a discovery cut?
Make sure you get those attachments emailed over to Ms. Holmes, please. Thanks. How do you say your last name? Barrier. And sir, you are Brian Barrier? You are Brian Barrier? Speak up, please, sir. Okay, sorry. I have a cold. I'm having trouble hearing. You need to speak loudly and clearly. Mr. Smith, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Barrier, in cause number 24, DCCR 0128, you're charged with the 3rd-degree felony offense of placing a serial number with intent to change identity from January 6th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Smith? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 3-year term in prison, but that would be probated. You'd be on probation for 3 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Barrier is not competent?
None, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at sentencing. Fabian Hall.
I've given you back the discovery page on that one, Bruce.
Good morning. Are you Fabian Hall?
Yes, ma'am.
And Mr. Smith, will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Hall, in cause number 24 DCCR 0758, you're charged with third-degree felony offense of injury to a child from February 3rd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Smith? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 7-year deferred probation. There would be a $1,500 fine. You would be required to follow all of the rules and conditions of probation, including entering and successfully completing a parenting course. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No, Judge.
It's admitted. Any evidence that Mr. Hall is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right over there. All right, we'll see you back at sentencing. All right, Cedric Franklin. Mr. Smith might get the gold star for the day. He does.
Good morning.
Good morning. You're Cedric Franklin. And Mr. Franklin, if you'll just take your hands out of your pockets. Thank you, sir. And Mr. Smith, will your client waive the formal reading of the indictment?
He does.
Mr. Franklin, in cause number 25, DCCR 1005, you're charged with a, oh wait, are we going on count 1 only?
Yes, Your Honor.
All right, give me just a second to pull that up. All right, so Mr. Franklin, in cause number 25, DCCR 1005, the state has elected to proceed on count 1 only. It alleges you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from May 10th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
Do you have take that out of your mouth. You're gonna walk up in court with a toothpick hanging out of your mouth? Did you enter your plea of guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Smith? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year term in prison, but that would be probated for 5 years. I don't, with the history,
Your Honor, he's successful. I know there's priors.
I'm fine with probation. I just don't like the fact that if he does not complete it, that 5 is, and that,
Would the court,
I just think on those,
since we were limiting it, would the
Since you're
court set the
limiting-
10 over 5?
Yeah,
Where the
yeah.
Probation term's not any different, just the
yes,
possibility of.
absolutely, because on all of these, and honestly, the one before this, I almost said it and I probably should have. I would much rather have, because depending on what the violation is, it may look very weird to do a 3 or a 5 if they violated their probation in some egregious way. Do you want to talk to him about that? I'm willing to accept the 5 years of probation, but the actual punishment, if he violates, I'm not going to cap that agree to a cap at 5 on that.
The other reason as well, that I know it was because the offense itself.
That one, it didn't have the history.
And I know why she did this. He successfully completed a probation about the time this happened, a 10-year probation out of Liberty County.
Yeah.
So I think that's the reason. I understand the court's concern.
Yeah. I just want that entire range of something. When you have history, the other one didn't have any.
He had one
history.
old stage,
Okay,
but
yeah.
nothing that enhanced.
Right.
It was like 20.
It's fine.
So the agreement, I want to make sure, as it stands on the paperwork now, the agreement was for a 5-year term in prison that would be probated for 5 years. And it's my understanding that you will agree to a 10-year term in prison, but it will still be probated for 5 years, which means if you violate, I could give you that 10 years, something in between, but it's not going to be capped at that 5. And you agree to that. With everyone's permission, I'm going to make that adjustment on the written admonishment.
No objection.
And that was a $500 fine as well. Is that your understanding? And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Franklin is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can get a pre-sentence report done by probation. It'll give me more information about you and your case, and then we will come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at sentencing.
Thank you.
Yes, sir. Thank you.
Thanks, Judge.
Thank you.
Dando un total de $208. Y el señor Chávez, usted dice.
We are on the record in BU 2025 TR 1341, State of Kansas versus Jorge Alexander Dubon Yanez. Please announce appearances.
On behalf of the state. ¿Qué tal, señor Aguirre, en representación de la Fiscalía?
Your Honor, Darren Patterson, appearing on behalf of Jorge Alexander Dubon Yanez.
Su señoría Darren Patterson, quien está compareciendo en representación del señor Jorge Alexander Dubón Yáñez.
Judge, this is a case where I've sent Mr. Regier an email, and I assume that is probably going to be acceptable, but I wanted to ask him first.
Su señoría, ese caso, yo le envié al señor Regier un correo electrónico y asumo que probablemente este vaya a ser aceptable, pero quería confirmar con el primero.
Jared Regier does appear for the state. Mr. Regier, do we have an agreement?
Señor Regier, que está compareciendo para la Fiscalía, ¿tenemos un acuerdo?
Your Honor, this is a case where
Count 2 is charged as an improper tail lamps. Count 1 is charged as no proof of insurance, a Class B misdemeanor. The state is prepared in this matter for purposes of resolving the case today to dismissing Count 2, the infraction, upon successful plea to Count 1, the Class B misdemeanor.
Su señoría, en este caso, nosotros tenemos una infracción 2, que es una infracción por no contar con las luces posteriores o con contar con luces posteriores inapropiadas. Una es una infracción de no tener prueba de seguro, que vendría a ser un delito menor de clase B. La Fiscalía está preparada en este caso, por el propósito de resolver este caso el día de hoy, desestimar la infracción número 2 bajo la declaración de responsabilidad de la infracción número 1, que vendría a ser el delito menor de clase B.
And Judge, I wouldn't ask this time that Mr. Duban Yanez will enter plea of guilty to the charge of no proof of insurance, Class B non-person misdemeanor.
Su señoría, quisiera solicitar en esta ocasión que el señor Dubán Yáñez estaría declarando su responsabilidad a la infracción de no contar con una prueba de seguro, que sería el delito menor de clase B.
Mr. Dubon, how do you plead to Count 1, driving without proof of insurance?
Señor Dubón, ¿cómo declara su responsabilidad frente a la infracción número 1, conducir sin prueba de seguro?
Culpable.
Guilty.
By pleading guilty, are you admitting that you did on or about March 26, 2024 in Butler County drive a motor vehicle upon a public highway or property while failing to have proof of insurance?
Mi señora, al declarar su responsabilidad, usted está admitiendo de que usted, él o aproximadamente el 26 de marzo del año 2024 en el condado de Butler, estaba conduciendo un vehículo motorizado en una autopista pública o una propiedad mientras no contaba con una prueba de seguro.
Sí.
Yes.
And were you driving around Southwest 140th Street and Southwest Prairie Creek Road, Rose Hill, Butler County, as the officer said in his affidavit?
Bien, señor, y usted estaba conduciendo alrededor de la Southwest 140 Street en Southwest Prairie Creek Road y Rose Hill en el condado de Butler, tal como el oficial indicó en su declaración jurada.
Sí.
Yes.
Is anyone making you enter your plea today by any threats or promises other than the plea agreement?
¿Habría alguien que esté haciendo ingresar su declaración de responsabilidad por alguna amenaza o promesas aparte de la que se le ha propuesto en el acuerdo de declaración de responsabilidad?
No.
No.
Do you understand you're giving up the right to a trial that you have with this plea?
Señor, ¿usted comprende que usted está renunciando a su derecho a tener un juicio al hacer esta declaración?
Sí.
Yes.
And do you understand with this plea you will most likely be found guilty and unable to appeal your conviction?
Bien, señor, ¿y usted comprende que con esta declaración lo más probable es que usted sea encontrado responsable y no tenga la capacidad de poder apelar su condena?
Sí.
Yes.
And again, you did not have insurance on the vehicle you were driving on March 26th?
Y nuevamente, ¿usted no contaba con un seguro en el vehículo que usted estaba conduciendo el día 26 de marzo?
La verdad no me recuerdo bien.
Honestly, I don't remember very well.
Do you remember what kind of vehicle you were driving?
¿Usted recuerda qué tipo de vehículo estaba conduciendo?
Una troca Avalancha 2003.
A truck, 2003 Avalanche,
Una blanca.
a white one.
And were you pulling a trailer?
¿Y estaba jalando un trailer?
Sí.
Yes.
What kind of trailer were you pulling?
¿Qué tipo de trailer estaba jalando?
O sea, una trailer era de mi patrón, una de
4 llantas, una trailer sencilla, no de dompe, una sencilla.
Well, it was my employer's trailer. It was a regular four-wheel trailer.
And you don't know if your truck had insurance on it or not?
Y usted no sabe si su camión tenía seguro
No,
en
no
ese
sabe.
momento.
No me di cuenta, nomás hice el favor para ir a tirar, para jalarle la trailer, nomás hice el favor. Pero no me pregunté nada de eso más.
Well, I didn't ask him in that moment. I just did him the favor of pulling that trailer, but I didn't ask him about it in that moment.
Mr. Patterson, I'm hearing your client say he's not sure if he's guilty or not, but yet he's pleading guilty.
Judge, he would, I'm sorry, go ahead, Jose.
Señor Patterson, escucha que su cliente está diciendo que no está seguro si es culpable o no, pero él está declarando su responsabilidad.
Judge, he does very clearly state that on the day stopped, he did not have proof of insurance. He would again state that same thing and plead guilty.
Su señoría, él dijo claramente de que el día que lo detuvieron él no tenía prueba de seguro y va a decir nuevamente lo mismo y declarar su responsabilidad.
Is that right, Mr. Dubon?
¿Es correcto, señor Dubán?
Sí.
Yes.
All right. I accept the defendant's plea as knowingly and voluntarily entered and find him guilty.
De acuerdo, acepto la declaración de responsabilidad del infractor, siendo consciente y voluntaria, lo encuentro responsable.
Sí.
Recommendations for sentencing, Mr. Regier?
Recomendaciones para la sentencia, señor Regier.
Your Honor, besides the court determining appropriate attorney fees, the state is prepared to recommend the minimum fine required by law of $300, that the court impose appropriate court costs, a suspended jail sentence of 120 days, subject to a 6-month non-reporting probation. The state has no objection to the court ordering credit for time served, given that the defendant appears in the fashion that he does today, if the court determines such an order is appropriate in this matter.
Su señoría, aparte de que, bueno, el tribunal determine las tarifas del abogado que sean apropiadas, la fiscalía está preparada para poder recomendar la multa mínima requerida por la ley, que es de $300, que el tribunal impondría apropiadamente también los costes judiciales y también una sentencia de cárcel suspendida de 120 días, sujeta a una libertad bajo palabra sin reporte con 6 meses de duración. La fiscalía no tiene objeción a que el tribunal ordene el crédito por el tiempo ya servido durante la presencia del infractor, que lo hace el día de hoy, si el tribunal determina tal orden sea apropiada en este caso.
Judge, we'd ask court to adopt the recommendations.
Su señoría, nosotros acompañamos y adoptamos las recomendaciones.
Mr. Dubon, how long has it been since you've been in jail?
Señor Dubón, ¿cuánto tiempo usted ha estado ya en la cárcel?
¿Cuánto ahorita tengo? 2 meses y medio. Yeah.
At this moment, 2 months and a half.
You have a job when you get out?
¿Usted tiene un trabajo cuando salga?
Sí, gracias a Dios me gusta trabajar.
Yes, thanks to God, I like to work.
Do you know, are you going back to the job you had before?
¿Usted sabe si estaría regresando al trabajo que tenía anteriormente?
Sí, no sé, es porque no he tenido comunicación, pero de todas maneras yo conozco mucha gente que me da trabajo.
Well, I haven't had communication with them, but I know a lot of people that I normally work with.
But you haven't worked for the last 2.5 months because you've been in custody?
Pero usted no ha trabajado por los últimos meses y medio debido a que usted ha estado bajo custodia.
Sí.
Ya.
All right. At this time, your fine is $300, your court costs are $108, and I'm waiving attorney fees.
Bien, en esta ocasión su multa sería de $300, los costes judiciales de 108 y estoy exonerando las tarifas del abogado.
Okay.
Your sentence will be 120 days in jail with credit for time served.
Su sentencia sería 120 días en la cárcel con crédito por el tiempo que usted ha servido.
You will not have to serve the remainder of your sentence, however, as long as you're successful on a 6-month non-reporting probation.
Usted no va a tener que cumplir con el resto de su sentencia, sin embargo, siempre y cuando usted complete exitosamente un periodo de libertad bajo palabra, sin reporte, con 6 meses de duración.
Okay.
Your probation will have 2 conditions. The first is violate no laws, and the second is to pay the 408 within 60 days.
Bien, su libertad, su libertad condicional, o mejor dicho, libertad bajo palabra, tiene 2 condiciones. La primera sería que no infrinja ninguna de las leyes y la segunda sería de que pague los 408 días en los siguientes 60 días.
Okay. 408.
408.
Yes, your fine is 300 and your court costs are 108 for a total due of $408.
Sí, señor, su multa es de $300 y sus costes judiciales son de $108, dando un total de $408.
Can you pay that? Is 60 days enough to get that paid? I can give you a little more if I need to.
Puede pagar eso en los siguientes 60 días. 60 días sería suficiente para poder pagar eso, porque le puedo dar un poco más si usted así lo necesita.
Okay. Si me da 3 meses.
If you can give me 3 months.
3 months or 90 days will be the order of the court.
3 meses o 90 días sería la orden del tribunal.
Okay.
Okay.
So if you violate no laws for 6 months and you pay that within 130 days, you will not have to serve the remainder of your 120-day jail sentence.
Bueno, si usted no infringe las leyes por 6 meses y usted paga esto dentro de los 130 días, usted no tendría que servir o cumplir con el resto de sus 120 días de sentencia de cárcel.
Okay. Son 90 días o 130. Y tengo que pagar.
Disculpe, ¿puede repetir la pregunta?
Esas 90 días que tengo que pagar los $408 son 90 días.
I have 90 days in order to pay the $408. Is that right?
That is right. And check with the clerk of the district court, and she'll tell you how to pay that. Her number is 316-322-4370, or you can stop at the courthouse when you leave the jail.
Sí, es correcto. Y confírmelo con el secretario del Tribunal Distrital y ella le estaría diciendo cómo puede pagar. Su número es el 316-322-4370. Usted también se puede detener en la sala, en el juzgado cuando salga de la cárcel.
Okay.
Okay.
All right, anything further, Mr. Regier?
¿Habría algo más, señor Regier?
Your Honor, if the court is finding that count 2 is being dismissed pursuant to plea negotiations, the state has nothing further.
Su señoría, si el tribunal está encontrando de que la infracción 2 sea desestimada debido a las negociaciones de la declaración de responsabilidad, la fiscalía no tiene nada más que añadir.
Count 2 is dismissed on motion of the state per plea agreement.
La infracción 2 estaría siendo desestimada a petición de la fiscalía por acuerdo de declaración de responsabilidad.
Mr. Patterson, anything further?
Señor Patterson, ¿algo más que añadir?
Nothing further.